for moving.
ಯಾವ್ದು ಈ ಬೆಂಚ್
ಇಲ್ಲ ಇಲ್ಲ.
ಬೇರೆ ಬೆಂಚ್
My lords.
ಏನು ನೋಡ್ರಿ
ಇಲ್ಲ,
ಕೋರ್ಟ್
ತಗೊಂಡಿರಿ.
ನಮ್ ಕೋರ್ಟ್ ಇದ್ದಾನೆ ಅದು ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಇದ್ದಾ
ಹೌದು.
ಡಿಫ್ರೆಂಟ್ ಕಾಂಬಿನೇಷನ್
My lords. Matter pertaining to this court.
ಇದೇ ಬೆಂಚಾ
This
ಏನು
court, my lord.
ಲೀಲೇಶ್
ಡಿಸ್ಪೋಸ್
KT.
ಮ್ಯಾಟರ್
KT matter, my lord. My pension has been
ತೊಡ್ರಿ ತಂದು ಮುಚ್ಚರ್ ಹಾಕೊಟ್ರಿ ಓಕೆ
urgency ಇದೆ, my lord. We had moved it last week.
ಈ ಬೆಂಚ್ ಮುಂದ್ ಮಾಡ್ಲೇಬಾರ್ದು ಎನಿವೇ ಯು ಹ್ಯಾವ್ ಡನ್ ನಾವು ಒಬ್ರಿಗೆ ಅಲೋ ಮಾಡಿದ್ದಕ್ಕೆ ಎಲ್ಲಾರನ್ನೂ ಅಲೋ ಮಾಡ್ಬೇಕಿತ್ತು ಓಕೆ
Your lordship's permission, my lord. My lord, item 25.
ರಾಜೇಶ್
My lord, item 25 before this bench, my lord. My lord, it is for hearing, but I have a personal difficulty. I am not in Bangalore today, my lord.
Rajesh sir, we'll
Yes, sir.
take everything in the first week of January,
ಫಸ್ಟ್
Very-
all the hearing matters.
Yes, please. I am obliged.
These last 5 days, a lot
Yes.
of rush for other things. Yes.
ಬೇರೆ ಕೆಲಸ ಎಲ್ಲ ತುಂಬಾ ಇದೆ ಅದಕ್ಕೆ
There's only one major subject which is pending, my lord, wherein a small area of house has been regularized, dwelling house has been regularized.
The
Surrounding areas left. Only that is a major chunk of litigation which is pending before this bench. Other, my lord, are day-to-day matters which will be there.
Yes.
And it's concerning one
Which
dwelling house.
They are there today.
They are listed today. Those matters can be taken for some day and decision can be passed on that. The other matters, my lord, will always be there.
Will post lunch of 20th will sit
Please, ma'am.
and
Those.
only those matters.
Yes, please.
ಎಷ್ಟಿದೆ ಅದು?
There are around 8 to 10 matters.
Only those matters.
only
will be
those
listed.
matters.
Yes, only those
Because
matters.
Having heard those matters, the only thing which will be left are the dwelling houses.
All right.
So those matters will be there until the litigation is complete.
Sounds good. Writ appeal is allowed. The order dated 29/11/21 passed by Leonard Single Judge stands is rendered unsustainable and is set aside. Writ petition 1140 of 2021 is allowed and is declared that the lands of the petitioner, the subject lands, have been dropped from acquisition for the purpose of formation of Dr. Shivram Karant layout.
My brother has written it very beautifully. He is known for writing such beautiful judgments is another thing, but it is even more beautiful.
Grateful.
ಕನ್ನಡದಲ್ಲಿ ಬರೆದಿದ್ದು ಬಹಳ ದೊಡ್ಡ ವಿಷಯ. ಕನ್ನಡದಲ್ಲಿ ಬರೆದಿದ್ದು ಬಹಳ
ಅದು yes.
ನಮ್ಮ ಕನ್ನಡಿಗರಿಗೆಲ್ಲ ಬಹಳ
Hardship has created history.
ಬರೀದಕ್ಕೆ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಬೇರೆಯವರಿಗೆ ಅರ್ಥನೇ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಇನ್ನೊಂದು ಪ್ರಪೋಸ್ ಮಾಡಿದೆ.
ಅದು ಈಗ
ಎಲ್ಲಾ ಜಡ್ಜ್ಮೆಂಟ್ ಕನ್ನಡದಲ್ಲಿ ಬರೀಲಿಕ್ಕೆ ಸ್ವಲ್ಪ ತೊಂದರೆ ಇದೆ. ಏನೇನೋ ಕಾರಣ
ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್ಸ್ ಆರ್ ಇನ್ವಾಲ್ವ್.
ಇಂಪಾರ್ಟೆಂಟ್ ಇರುವಂತದ್ದು. ನಂತರ ಎಲ್ಲಾ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಇದೆಯಲ್ಲ ಅದನ್ನ ಕನ್ನಡದಲ್ಲಿ ಬರೀಬೇಕು ಅನ್ನೋದು ನನ್ನ ತುಂಬಾ ದಿನದ ಒತ್ತಾಯ ಆಗ್ರಹ. ಅದು ಏನು ಅಲ್ಲ, ಇದು ಒಂದು ಕಂಪ್ಲೀಟ್ ನಾನು ಇದಲ್ಲ ಎಲ್ಲಾ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಈಗ ಲಿಟಿಗಂಟ್ ಓದೋದು ಅದಷ್ಟೇ
ಜನರಿಗೆ ಅರ್ಥ ಆಗುವಾಗ
ಅರ್ಥ ಆಗುವಂಗೆ
ಅದಷ್ಟು
ಇರ್ಬೇಕು.
ಮಾತ್ರ ಬರುತ್ತೆ.
Ultimate litigant is bothered about the operative portion.
Not about anything.
No school. Dismissed.
Obliged.
Madam,
The report of the registrar computers, 7324. What was
that
my
on
past on that?
20th will clear that report of registrar
Because
computer.
there are certain reports which are pending approval.
On that day we'll close it.
That day, my lord, if some certainty is there insofar as the application is concerned,
Yes.
many petitions.
Which
will be disposed.
application?
No, 7/3/24, that report, applications of the applications before the committee, which were decided by the committee,
Yes.
but not approved by the Supreme Court. So
No,
those are-
that we will decide on the next day.
Yes.
20th. 20th. Twentieth. ಇದೆಲ್ಲ those matters ಯಾವ್ದು ಹೇಳಿ, ಮಿಕ್ಕಿದ ಮ್ಯಾಟರ್ ಎಲ್ಲ ವಿಲ್ ಅಡ್ಜರ್ನ್.
I'll pass on the list.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಇವತ್ತು?
Yes.
ಹಾ ಹೇಳಿ.
ಆಲ್ರೆಡಿ ಇವ್ರದ್ದೇನೋ ಇದ್ರಂಗಿದೆ.
ಅವ್ರ್ದು ಯಾವ್ದು ಇದೆ?
This matter, my lords, posted for orders. I filed the amended writ petition, my lords.
ಅರೆ ಮತ್ತೆ
No, I filed it.
Ah.
4-day delay in filing it. It's for orders on that, man.
non-compliance, obvious objections raised in amended petition. What is that? Cost title?
I have long cost settled it, my lords. I have
Long cost title
on that.
or wrong cost title?
Long.
Okay, fine.
I have complied with.
Yes. Office objections overruled. IA is filed or what?
I has
But-
been filed, allowed. I've already carried out the amendment and filed the amendment.
All right. Office objections overruled. Post the matter. Cost title corrected proper. Cost title na ಸರಿ ಇಲ್ಲ ಅಂತಲ್ಲ.
I'll verify. I'll verify immediately.
Every week you're coming up
No,
with
I
some
apologize.
objection. What is this? That is better. Office objections overruled. List the matter for list the matter in the fresh matters list on say on 8th, 9th January.
Oh,
Consider it.
Petition.
Representation.
No, it's on the last date of hearing, interim order was granted.
Consider it.
ಅವಾಗ ನೀರನ್ನ ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಬಿಡಿ ಅದು.
ಇಲ್ಲ. ಇಲ್ಲ.
Milords,
ಯಾಕೆ
that-
ಹಿಂಗ್ ಮಾಡ್ತೀರಿ?
Yes. So if that is the case, my lord, then.
Water disconnection.
ಇಲ್ಲ.
ಹೌದು,
ಅಷ್ಟೇ ಅಷ್ಟೇ. Close ಮಾಡಿ. The second section. The petitioner is before this court. Petitioners are before this court calling in question. And the notice dated 22/4/2024. The learned heard so and so. The learned counsel for the petitioner submits that apart from calling in question the notice, a representation is apart from calling in question the notice, a direction is sought by issuance of a writ in the nature of mandamus, directing consideration of the representation submitted by the petitioner on 18/4/2023 to regularize the factory shed constructed on the land in survey number 58/1 capital A3 as submitted in the application. The learned counsel for the petitioner submits that the representation of the petitioner is not considered for the purpose for which it is rendered, and notwithstanding its non-consideration, the water connection in the factory premises is cut by the BDA. The learned counsel for the respondent Shiva Prasad Shantangowda would submit that if reasonable time is granted, he would consider the BDA would consider the representation in accordance with law and communicate such order that is passed upon the representation to the petitioner, and would further submit that till the representation is considered and disposed, disposed. Therefore, we deem it appropriate to direct the BDA to consider the representation and dispose the same in an outer limit of
8 weeks.
8 weeks, if not earlier. The decision taken on the representation be communicated to the petitioner till the decision is taken decision is taken by the BDA upon the representation. The status quo, the property be maintained by the parties. In the light of the water connection being disconnected, the learned counsel, as submitted by learned counsel Shiva Prasad Shantangowda, steps shall be taken forthwith to restore the water connection in the property, all of which would be subject to the outcome of the representation that would merit consideration at the hands of the BDA as observed here in above, ordered accordingly. Ninth.
My senior is on.
9th January.
Okay.
All 6, 7.
9th.
9th for the petition.
Please, ma'am.
Yes, madam.
Road.
ಎಲ್ಲೆಲ್ಲಿ ನಾವು ಹೇಳಲ್ಲ.
They left out in PN, small construction.
Taken up on 20th, small construction is put up
This
on
is
a larger
20th.
extent.
List on 20th next week. ಅಷ್ಟೇ.
After vacation.
9th. ಇಲ್ಲ.
Taken up on 20th.
20th, yes.
10 education.
10 ಅದೇನಾ? 10
10.
List on 20th. Interim orders.
In this, may I just make one submission? Lords? Now, an extent of 1 acre is regularized in favor of a school. That consists of certain dwelling houses which had come up adjacent to the school. The portion earmarked, my lords, for the purpose of a playground has since been acquired for formation of a road. In the sense, my lords, road has already come. Now, adjacent to my 1 acre land, there is another extent of vacant land. If the allotment, my lords, of the area which is going for the purpose of road widening and other area which has not been regularized is allotted adjacent to mine where there is some vacant
Similar
land.
aspect we considered in
Madam Monica Patil.
in terms of that order ಮಾಡಿ ಕಳಿಸ್ಬೋದು.
Yes,
Do you have that copy?
no, madam.
We'll duplicate that order in this also, identical grievance.
But he wants.
As far as possible.
Yes, in the petitioner's case, what the petitioner is seeking is he wants the entire one extent of land. He doesn't want the farm sites.
If possible, that you have to explore,
That will explore, but
so that he can make use of that.
yes.
He has not seen that.
You
No,
just-
you have not seen that order.
No, my lords, I have not.
We'll post it
No,
on
no,
20th.
20th, my lord.
20th,
20th
that
we'll
day.
dispose.
Please. Pledge.
20th.
20th. 20th.
20th, sure.
12 will not have.
9th. 9th January ಕೊಡ್ತಾರೆ.
20th
ಯಾವ್ದು 12 ಯಾವ್ದು ಇಲ್ಲಿ ನಮ್ಗೆ ಬಂದೇ ಇಲ್ಲ, ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ. ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್?
ಅದೇ to consider the so far with the ಒಂದು ಆರ್ಡರ್ ಹಾಕಿ ಅದರಲ್ಲಿ ರೆಗ್ಯುಲೈಸ್ ಆಗಿದೆ.
ಹೌದು ಪುಟಪ್ಪ ಆಯ್ತಾಗಿ
Yes, sir.
In 12th, my lord, I have made an amendment application formal that can be allowed.
12 ಅಲ್ಲ.
12,
Agli, you have the objection haki.
No, but it may be allowed.
ಅದೇನಿಲ್ಲ, it's a
ಎಲ್ಲಿದೆ
minor.
application? 12 ಅಲ್ಲ.
It's not been
12.
put up maybe.
Put up
Immediately
ಆಗಿರ್ಲಿಲ್ಲ.
copy.
ಇಲ್ಲೇ.
That notification would not been questioned, notification acquiring it for road, ಅದನ್ನ amendment.
Heard the learned senior counsel, Shri Ashok Karnataka appearing for the petitioner. The petitioner has preferred an application in IA so and so ನೋಡ್ಕೊಳ್ಳಿ. Raising a challenge to the notification dated 2/11/2022. ಅಲ್ಲ, notification ಏನು?
Notification data.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
2/11/22.
20, ಅಲ್ಲ, 23/8/22. Notification dated 20.
2/11.
ಅಲ್ಲ, ಇಲ್ಲಿ
Order date.
in view of the buildings.
6822. 6822.
ಅಷ್ಟೇ ಸಾಕು. So has preferred an application seeking incorporation of additional grounds and additional prayer for the reasons indicated in the affidavit accompanying the application and being satisfied with the same. The application stands allowed the petitioner to file an amended petition by the next date of hearing, list on 9th.
Let serial number 24, 30 to 39, all similar.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅಡ್ಜನ್ ಮಾಡ್ಬಿಡ್ತು.
24, 20 serial numbers?
24 ಅಲ್ಲ ಈಗ ಮಾಡಿದ್ದು 12.
ಈಗ 12 connected with serial number 24,
ಹಾ
30 to 39.
yes sir. 30 to 39, 32 and 39.
ಕಾಲ್ ಔಟ್ ಆದಾಗ ಹೇಳ್ತೀವಿ.
Please, my lord, I beg to appear for the response. So petitioner.
13, consider representation.
ಯಾವ್ದು 13
Number
madam.
13. Annexure R and R1.
ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು.
Please, my lord.
The petitioner is before this petitioner note others ಇಲ್ಲದಿತ್ತಲ್ಲ 13 others. The petitioners are before this court seeking a direction by issuance of a writ in the nature of mandamus to consider the representation dated so and so. The learned counsel for the petitioner submits that the petitioners have, by venting out their grievance in the have submitted a representation to the respondent BDA on 3/10/2022 and 3/10/2023, which are appended to the petition as annexures R and R1. The same has not yet met its consideration at the hands of the BDA. Therefore, the petitioner, learned counsel for the petitioner would submit or restrict his prayer at this juncture for consideration of the representation submitted to the BDA as quoted, as noted supra. The learned counsel appearing for the BDA submits that if reasonable time is granted, the representations would be considered on its merit and appropriate orders would be passed in accordance with law, and the same would be communicated to the petitioners. In that light, without going into the merit of the claim of the petitioners, we deem it appropriate to dispose the petition to, by a direction to the respondent BDA to consider the representations dated 28/11/22 and 3/10/2023 in accordance with law. The decision taken on accordance with law within 8 weeks, if not earlier. The decision taken on the representation shall be communicated to the petitioner, shall be communicated to the petitioner. Idರಲ್ಲಿ enter ಮಾಡಿದ್ಯಾ?
Please, my lord.
Till the decision is taken upon, till the decision is taken upon the representation of the petitioners, the parties to maintain status quo. Ordered accordingly.
Great.
There's a fresh matter, my lords. Lords have sought for a direction to consider representation. In fact, my lords, in respect of adjacent site holders, my lords, a writ petition, my lords, was disposed by your lordships, my lord.
Page as.
My lords,
Sir, P1 and P2.
WP number 25412 of 2020. That order is not.
To read petition number?
My lords, 25412, my lord.
The. 2541 ಬರ್ಕೊಂಡ್ರ 25412 of
2024.
2024. ಇದಕ್ಕೆ ಇದ್ ಮಾಡಿ. The
It's the very same
petitioners are before
representation.
this court calling, seeking the following prayer, heard so and so. The learned counsel for the petitioner submits the adjacent landowners, this court has directed consideration of their representation by their representation. The learned counsel would submit that if an identical order is passed in the case at hand, directing consideration of the representation submitted by the petitioners, it would suffice at this juncture, suffice for the present. In this bench, while disposing this so and so writ petition, has directed consideration of the representation in those cases by the following order. In the light of the petitioner, in the light of the fact that the petitioner's land is adjacent to the one that fell for consideration in the aforesaid petition, we deem it appropriate to direct consideration of the representation of the representation of the petitioners by the hands of the BDA within 8 weeks from the date of receipt of the copy of the order, if not earlier. Till such time, status quo will maintain.
Great.
Twentieth.
20th. Heard others. ಮಾಡಿ.
In the earlier matter, I'm sorry, 14 notice has to be issued. It was a fresh
ಯಾವ್ದ್ರಲ್ಲಿ?
matter. Seal number
14
14.
ವಿರೂಪಾಕ್ಷ ಇದಾರಲ್ಲ.
Yes.
ಆಯ್ತಲ್ಲ ಅದು?
Yeah.
ಅದರಲ್ಲಿ ಈಗ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಮಾಡಿದ್ವಲ್ಲ, ಅದರಲ್ಲಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್, ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಶಿವಪ್ರಸಾದ್ ಶಾಂತ್ ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡಿ, ಲರ್ನೆಡ್ ಶಿವಪ್ರಸಾದ್ ಕೌನ್ಸಿಲ್ ಶಿವಪ್ರಸಾದ್ ಶಾಂತನ್ ಗೌಡ್ರು accepts notice for the BDA, ಲರ್ನೆಡ್ AGA for the state ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡಿ, ಆಮೇಲೆ ಹರ್ಡ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಂತ ಮಾಡಿ.
The 20th. 15th is 20th.
20th. ಇದು ನೋಟಿಸ್ ಫಸ್ಟ್ ಟೈಮ್
First time.
ಫಸ್ಟ್ ಟೈಮ್
Objections ಹಾಕಿದ್ದೀರಾ?
ನೋಟಿಸ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಶಿವಪ್ರಸಾದ್ ಶಾಂತನ್ ಗೌಡ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ಸೇಮ್ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೆ AGA 1 ಲಿಸ್ಟ್ ಆನ್ 20th.
Check ಮಾಡಿ. ಮತ್ತೆ.
ಇದು ಫಸ್ಟ್ ಟೈಮ್
For the first time, Lord, but
ಸೇಮ್ ಮಾಡಿ.
similar matter. Your Lordship said directed me to file a representation to the BDA. This is a matter wherein
ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಯಾವುದು?
similar. Approach the wrong committee, my Lord. Lordship said,
Oh,
the previous
Lord.
occasion, please.
Wrong committee. We'll direct them to approach the right committee. Yes. The petitioner is before this court seeking the following prayer. Heard first time I will notice separate order sheet al ಮಾಡಿ, heard so and so ಅಂತ ಮಾಡಿ. The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that his grievance is identical to the one considered by this court in writ petition 30135 of 2024, in as much as the petitioner has also approached the wrong committee seeking redressal of his grievance. This bench by an order dated 23rd November 2024, considering the identical grievance, has held as follows. Court ಮಾಡ್ಬಿಟ್ಟು. In the light of the issue already being answered of an identical grievance, we deem it appropriate to directly BDA to we deem it appropriate to direct the petitioner to submit a detailed representation within 4 weeks from today, and the respondent BDA shall consider the same within 8 weeks and thereafter pass necessary orders with regard to the grievance of the petitioner. Grievance of the petitioner as would be submitted in the representation. Any information that is necessary from the petitioner shall be solicited by the BDA, and the decision taken shall be communicated to the petitioner. Therefore, said observation petition stands disposed. Till the consideration of the representation as observed herein above, the parties to maintain status quo qua the construction in the subject property. Ordered accordingly.
Consider representative.
Consider.
Annexure.
The petitioners are before this court seeking the following prayer. The
Yes, no, sir. Civil number
heard sounds.
20, no, sir. No, sir.
The petitioners who claim to have jointly acquired the subject property, which has now become the subject matter of acquisition for the purpose of formation of Dr. Shivram Karant layout, have submitted a representation to the respondent BDA to consider regularization of regularization certificate issue ಮಾಡಕ್ಕೆ.
If it has been,
Huh?
if it has been regularized, my lord, we'll take steps to issue.
To regularize respective house by issue.
To regularize means,
Submitted a representation to regularize the subject property by issuance of a certificate. The learned counsel for the petitioner submits that ಬೇರೆ ಏನಿಲ್ವಲ್ಲ, prayer ಏನಿಲ್ಲ. Learned counsel for the respondent BDA submits that if reasonable time is granted, the representation of the petitioner submitted in terms of annexure A and B would be considered and appropriate orders would be passed in accordance with law. The submission is placed on record, and in the light of the said submission, we deem it appropriate to dispose the writ petition with a direction to the BDA to consider the representation of the petitioners in accordance with law within outer limit of 8 weeks, if not earlier, till the consideration of the representation happens. The construction happens, parties to maintain status quo with regard to the construction of the building in the subject property, ordered accordingly. It is made clear, we have not considered the merit of the claim of the petitioners or the defense of the BDA. Twentieth, 9th January, heard the learned senior counsel. Sir, what is this matter?
22 notification.
Vacant land 22 notification.
Huh?
Vacant land 2022
Notification. Heard the learned senior counsel, Ashok Karnataka appearing for the petitioner. List the matter on 9th January.
20th.
List on 20th.
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 Till number 28 also.
Barley. 9th, list on 9th January.
20th.
20th. Why?
20th.
No, these matters are on 20th, we'll finish.
Similar matter.
8 to 10 matters are there, that's all.
Yes.
One sufficient, serial number 6, this post down is 9. Interim order is not.
Happy waits, don't worry.
Regularized portion road.
9th, 20th.
I got to make some submission on last date of hearing.
Road, the regularized building coming on road last time, orders
Same, we
were
have disposed all those matters. We have disposed 8 to 10 matters.
Yes, I was present, but at
Of
the
course.
same time, so far as this matter was concerned, upon my request, the honorable court, it may have it on 20th or 9th.
9th,
20th,
20th.
20th.
Interim order.
On the last day and the last hour of the year, you can finish your submission.
Maybe subject to the convenience.
That is the last working day.
Subject to the convenience.
So our last hour of the year.
Could 9th be considered 20th? I give it to the honorable
Yes,
court.
for the extension.
Maybe the new year.
Extension of time.
Yes, my lord, may consider it keeping for 9th, otherwise it is.
9th, list on, yes.
Interim order.
It's also coming on road.
I filed, before my lord, I filed NOC Vakal.
9th,
And my lord, I filed application as, I filed in serial number 14. Similar application has been filed in this as well.
ಏನು ರಾಂಗ್ ಕಮಿಟಿ
My lord,
14 ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ವಲ್ಲ
Consider representation.
ಅಲ್ಲ 14 ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೀವಿ
14, my lord,
serial number 12, apologies, serial number 12.
ಹಾ
Senior counsel, Ashok Karnataka appeared.
Additional prayer you have.
ಅಮೆಂಡ್ಮೆಂಟ್
Amendment.
ಅಪ್ಲಿಕೇಶನ್
Indeed.
ಸೇಮ್ 12 ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದೀವಿ ಅದೇ ಹೇಳಿ ಲಿಸ್ಟ್ ಆನ್ 9th. ಅಮೆಂಡೆಡ್ ಪೆಟಿಷನ್ ಒಂದು ಕೊಡಿ ಕಾಪಿ ಅಲ್ಲೊಂದು ಹಾಕ್ಬಿಡಿ ಪೆಟಿಷನ್ ಟು ಸರ್ವ್ complete set of amended petition papers to the counsel for the respondents. Yes,
9th.
list on 9th.
So vacant land 22 notification. 20th. 20th.
Regularized portion.
20th.
20th, last hour. Yes.
Entry model is there.
Twentieth.
20th.
Twentieth.
20th, yes.
Yes.
Twentieth.
Similar application has been filed.
Same as, model, same as 12. 12.
Number 31.
Ninth.
January 9th. List on me.
For 32, we Ramesh.
No, ಬಿ ರಮೇಶ್ ಆರಾಮಿಲ್ಲ ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಇವ್ರೇನ
ಬೇರೆ ಮೆಶ್.
ಬೇರೆ
ಇಲ್ಲ. ಯಾರಮಲ್ಲಿ? Not there. 9th.
Is there yesterday? Ninth.
ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ actually. Last time ಕೇಳಿದ್. He is disputing Google Earth.
33, 34 and 35, my lord. In all these petitions are filed similar applications.
Same, cell number 12. 33, 30.
Buildings coming on road, my lord.
ಇಲ್ಲ ಇದೆಲ್ಲನಾ?
ಎಲ್ಲ.
ಅದ್ಯಾವ 9th ಮಾಡೋಣ? 9th, yes.
Already my lords have passed an order, it will apply to them also.
Amendment allow ಆಗ್ಲಿ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೋ ಆಗಿ
Yes.
ಅದೇ amendment allow ಆಗ್ಲಿ, it will
Yes.
come on 9th. File an amended petition, copy to serve, ಅವೆಲ್ಲ ಮಾಡಿ.
P6, the town Nagaland.
9th.
Twentieth. 20th.
20th.
38, roll number.
20th,
It's coming on road. Last time it was listed 9th.
petrol pump, correct.
It's a larger extent of land, whether they're to be entitled as the smaller site owners, where on land to land basis, whether they can be compensated or not is the question. Because there are
ಓನ್ಲಿ ದಿ ಹೌಸಿಂಗ್ ಅಕೊಮಡೇಷನ್ ಶುಡ್ ಬಿ
60,000 square feet.
Taken up a contention that may be.
Commercial,
It has been regularized for commercial purpose itself. Regularization certificate, not issued.
It's not issued. It was rejected.
yeah. So
Rejected ಅಲ್ಲ? It
ಹೌದು.
was a-
rejection was
No.
challenged.
No, not
ಅದಲ್ಲ.
approved at all.
ಸರಿ.
Submission. If the objections, please take them, that regularization has been withdrawn. Don't know if
Yes.
it's as per the orders we on to the Supreme Court or they themselves have withdrawn. I'm not sure.
No, we can't withdraw. The committee has withdrawn.
Ah,
Or withdrawn on the ground that that structure is coming on road. Now we have to see, my lord,
Even
the revised master plan came in there 2007.
That
The
now
petrol
is placed-
yeah,
Yes.
logically you tell us that if the petrol pump is coming on the road where RMP formation is the road, should we save it?
It's not about
As-
question,
but
it's
alternate
not really
care.
about-
Alternate, ಅಷ್ಟೇ. That's what,
Alternate.
alternate if it is dwelling house.
Dwelling house, my lord, then
Commercial alternate ಎಲ್ಲಿದೆ?
Correct.
Compensation ಅಷ್ಟೇ.
The compensation. I'll just challenge that at least.
Which one?
Withdrawal, whatever withdrawal they have made. Whether it's.
Withdrawal is now appended to the objections.
Statements made.
Even then,
I'll just put it.
Allah, for your satisfaction, you may challenge it, but that does not turn the tables at all.
now what happens, my lord, in the meanwhile, there is an order of status quo. We are unable to proceed ahead because it's a bigger extent of land.
20th.
Finally 20th. ಇದು ಕಾಂಪನ್ಸೇಷನ್ ಅಷ್ಟೇ ಇರೋ ಅಷ್ಟೇ.
ಅಂತದೇ ಎಷ್ಟಿದೆ ಬಂಕ್ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಇರುವಂತದ್ದು
ಕಮರ್ಷಿಯಲ್
Around 10 structures,
ಅಲ್ಲ ಎಲ್ಲದರಲ್ಲೂ ಪೆಟ್ರೋಲ್ ಪಂಪ್ ಇದೆಯಾ?
not petrol bunk, but there are
Commercial.
commercial. Yes,
Filed a similar application for amendment.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ತಗೊಂಡು ಮುಗಿಸ್ಬಿಡ್ಬೇಕು. Vacant land of 2008, 22, right? Yes,
Buildings are come.
Google Earth, sir.
This matter especially, my lord, there is a building.
Only this matter, ಬೇರೆದ್ರಲ್ಲಿ ಏನು?
Only other matter, as per them, there is no.
As per Google. Yes.
Number 14. From Jio Prakash.
ಶಿವಪ್ರಕಾಶ್ ಇಲ್ಲೇ ಇದ್ರಲ್ರಿ.
Road.
Vacant land 28.
ಆಗ 9th. List on 9th.
They say it's a 1 acre of land, animal husbandry, there is no independent ingress and egress. Yes. 1 acre of land, my lord. They say there is no independent access at all.
Sorry. Yes. 9th.
9th.
Shankar Reddy.
They are seeking regularization of site 9th.
9th. Yes.
Entry ಮಾಡಿದ್ಯಾ?
Idre continue. If any subsisting today, will continue. 42.
We had shown the Google map image show that there was no structure as on day of notification. Only now it has come up. We filed objection memos also placed on it.
We had taken loan before 2018 for construction of.
2018. What is the cutoff date? is 38?
2018.
18. ಯಾವಾಗ ಲೋನ್ ತಗೊಂಡಿದ್ದೆ ಯಾವಾಗ?
Loan ಯಾವಾಗ ತಗೊಂಡ್ರಿ?
2017.
ಹಾ.
2017.
Producing 26.
ನೋಡಿ.
First installment of loan was released to you when?
Loan release ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
Release ಆಗಿದ್ದೆ ಯಾವಾಗ?
2017.
ಕೊಡಿ.
The memorandum of deposit of title deed is also on 18/5/2017.
The loan sanction
Number
ಮಾಡ
4.
2017 loan was disbursed.
ಇದಂಗೆ ಕಾಣ್ತದೆ.
ಅಲ್ಲ ನೀವು ಕ್ಲಿಯರ್ ಮಾಡಿರೋದ್ರಿ ಲೋನ್.
Here, in a
EMI ಎಲ್ಲಿದೆ?
statement of
Ah,
accounts
yeah,
also we have produced in page number 10 to 17. In 2022, we have paid the loan. Also, loan paid receipt is in page number 18.
So construction, you have completed construction?
Yes.
Where are the other statutory clearances? Construction ಗೆ? Huh? Huh. Check this, ನೋಡಿ.
But as
Their
on,
structure come up, loan ತಗೊಂಡು ಸುಮ್ನೆ ಏನು EMI ಕೊಡಲ್ವಲ್ಲ?
yes.
There should be some.
Structure came up after the cutoff date, not on the day of cutoff.
No, no.
ಇಲ್ಲಿ 17 ತಗೊಂಡಿದ್ದಾರೆ.
17
6/4/2017.
For construction, they have,
ರಿಲೀಸ್ ಆಗಿದೆ.
they have released for construction.
Correct.
But the issue is whether they have constructed on that day or not. They have not constructed because they have produced the Google map images.
ಅದಕ್ಕೆ
Their construction has come up after the cutoff date. As of today, there is structure.
ಬ್ಯಾಂಕ್ ಹೌಸಿಂಗ್ ಲೋನ್ ಸ್ಕೀಮ್ಸ್ ನಲ್ಲಿ because of the apex court judgment, the installment shall be released as against the stages of construction ಅಂತಿದೆ.
Even,
ಹಂಗಾಗಿ ಆ ಪ್ರಿಸಂಪ್ಷನ್.
yes, probably my lord, at the time of plan
first
sanction, certain
30%
amount of,
ಮಾತ್ರ ರಿಲೀಸ್ ಮಾಡೋದು.
probably at the time of plan sanction approval, some amount was released. It goes, these may be those
No,
amounts.
30% is released to show that they have commenced construction. ಆಮೇಲೆ stage wise it is released. ಅದೇ ಬೇಕಾಗಿದೆ.
These
ಇಷ್ಟು
are all,
ಕೊಟ್ಟಾಗ ಜಾಸ್ತಿ.
Object is that they should not be put to hardship ಅನ್ನೋದು
Yes.
ಒಂದೇ. If
If there
whatever
is
they have
construction,
done, that's.
produce the map, that is the only document we are relying on, because as on the day of cutoff date, there was no structure in place. It's only thereafter the
yes,
structure has come.
Rajesh, sir, you have to produce to the contrary.
And thereafter, my lord, they'll have to at least have to show whether they have taken permissions or not.
That's what statutory documents. ಕೊಡ್ಲಿ.
Documents ಸ್ಯಾಂಕ್ಷನ್ ಇದನ್ನೆಲ್ಲ ಕೊಡಬೇಕು. ರಾವ್ ಅವೆಲ್ಲಿದಾವ್? ಅವ್ ಮನೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡುವಾಗ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಎಲ್ಲಿದೆ? ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಎಲ್ಲಿದೆ?
License ಕೊಟ್ಟಿದ್ದಾರೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Contract agreement. But
That's not the point.
original.
You cannot put up the construction without sanction plan and building license. Where are they? ಅಂತ ತೋರಿಸಿ ಮುಗಿದೋಗತ್ತ.
In the next day.
In 64, my lord, in page number 64 of their petition, the concerned Gram Panchayat has granted the license to
When?
put
ಯಾವಾಗ
in 2017, May 2017. Gram Panchayat. They produced that doc.
ನೋಡಿ ಬೇರೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. 20th ಒಳಗೆ ಮಾಡ್ತೀರಾ? 9th January.
You may be extended.
Huh?
Interim order.
That's one election. Heard the learned counsel appearing. What's your name?
Moga.
Learned counsel
Amoga
Amoga
Varsha.
appearing for the petitioner. The learned counsel places on record certain documents to buttress his submission that the loan was secured from the hands of the non-banking financial institution way back in 2017, i.e. 6/4/2017. Long before the cutoff date fixed by the apex court, which is 3/8/2018. The learned counsel shall place on record all other statutory clearances for purpose of construction by the next date of hearing. As the contention of the learned counsel Shivaprasad Shantan Gaudar is, as on 3/8/2018, Google Earth images would depict no structure in the subject property. Yes, list on 9th. ಈಗ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ಟು ಮತ್ತೆ ನೀವೇ ಕೇಳ್ತಾ ಇದ್ದೀರಿ.
Twentieth. Twentieth.
20th, list, Rohan, yes. 44 ಏನು?
44, similar, 20th.
20th. ರೋಹನ್, ಇದು ಅದೇನಾ ರೋಹನ್?
Coming on road.
ಅವತ್ತೇ ಮಾಡೋದ? 9th ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ?
The intermodal was subject to me withdrawing the civil suit and approach the civil court.
What, yes,
The presiding officer was on leave.
by the next date you
By the next
comply.
date,
We need not pass any order.
no order.
ಇದೇನು ಸ್ಪ್ರಿಂಗ್ ವ್ಯಾಲಿ?
Club, my lord, this. 20th, madam. They're seeking larger extent to be dropped from acquisition. This is a farmers association ಅಂತ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅದೇ
Spring Valley Club is.
list on 20th.
On behalf of the learned AG, my lord, one other submission. Order
Really,
to be
there-
passed on calling for application.
We expected that actually. We thought you would mention it at the beginning of the session.
Because my lord, they're raising huge amounts of money on loan.
The session, Belgium session is going on. Even if we pass order, nothing will happen. Everything has to happen there now, and it is happening also. It is happening also. Let us see on the next date.
At disposal, yeah.
Sir.
ಇನ್ನೂರು ಕೊಡ್ಬೇಕು ಅಲ್ಲ ಡೇಟ್ ಮೊನ್ನೆ ರಜಾ ಇತ್ತಲ್ಲ ಅದು ಇದು ಎರಡು ಕಮಾಂಡ್
Yes.
With my lordship's kind permission, my lord.
Yes, brother.
My lord, serial number 9, my lord, may I request for a week's accommodation. I've informed the other side. My learned senior counsel is, sir, some inconvenience, my lord.
There is objection from Mr. Naik now. Bani, bani. But last time ಹೆಂಗಾಗಿದೆ? Yes. That's what. Yes. ಯಾಕೆ ಏನಾಗಿದೆ? ಅದು ಯಾವ್ದೋ ಒಂದು ಜನವರಿ 2nd week ನಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಡು. 10th of January on health ground of arguing counsel appearing for the respondent. ಯಾವ respondent? Respondent. Sole respondent. Okay. ಇಲ್ಲ. All. ಅವ್ರಿಗೆ ಆರಾಮಿಲ್ಲ. Next. 10th of January. Okay.
Pertaining to Begorman for evidence, name number 1, and
ಶಿವಪ್ರಕಾಶ್ ಒಂದ 10ನೇ ತಾರೀಕಿಗೆ ಹಾಕೋಣ ಎಲ್ಲ ಇಪಿಗಳನ್ನು 10th of ಹಾಕೋತಾರೆ. ಹೌದು 10th ಹಾಕೋಣ. ಇದೊಂದು ಒಟ್ಟು 3 ವಿಪಿ ಇದಾವು. 10th ಹಾಕೋಣ. We know that time is good running out. Yes. ಮತ್ತು ಮರಳಿ ನಾಗರಾಜ್ ಅವರು ಕೊಟ್ಟಿದ್ರು ಆ ತೀರ್ಪನ್ನು. ಅವ್ರಿಗೆ ಯಾರು ಸಪೋರ್ಟ್ ಮಾಡಲಿಲ್ಲ. ಆನ್ ದ ಅದರ್ ಹ್ಯಾಂಡ್ ಅವ್ರಿಗೇನೋ ಅಪೋಸಿಷನ್ ಮಾಡಿದ್ರು ಕನ್ನಡದಲ್ಲಿ ಬರೆದಿದ್ದಕ್ಕೆ. ಮಾಡ್ಬೇಕು ಎಲ್ಲರೂ ಕನ್ನಡ. ಯಾವುದೇ ಭಾಷೆಯ ಉಗಮ, ಉತ್ಥಾನ, ಅವಸಾನ 3 ಬಳಕೆಯ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ. ನಮ್ಮ ಪ್ರೊಫೆಸರ್ ಕಲಬುರ್ಗಿ ಹೇಳ್ತಿದ್ರು, ಭಾಷೆ ಬಳಕೆಯಿಂದ ಬದುಕುತ್ತದೆ. ಇಲ್ಲಪ್ಪ ನಮ್ಮ ಮುಗಿದೋಗ್ಬಿಡ್ತು. ಮತ್ತೆ ಬರೀ ಭಾಷೆ ಹೊತ್ತು ಇನ್ನೊಂದು ಭಾಷೆ ಬಂತು, ಹಂಗಿಲ್ಲ. ಭಾಷೆ ಮತ್ತು ನಾಗರಿಕತೆ, ಸಂಸ್ಕೃತಿ ಒಂದಕ್ಕೊಂದು ತಳಕೆ ಹಾಕೊಂಡವು. ಆ ಭಾಷೆ ಹೋದ್ರೆ ಎಷ್ಟೊಂದು ದಾಸ ಸಾಹಿತ್ಯ ಇದೆ, ಬಸವಾದಿ ಸಾಹಿತ್ಯಗಳಿದಾವು. ಅದ್ರ ಜೊತೆ ಅವು ಹೋಯ್ತು. ಅವನ್ನೆಲ್ಲ ಅನ್ಯ ಭಾಷೆ ತರ್ಜುಮೆ ಮಾಡೋದ್ರಿಂದ ಉಳಿಯಲ್ಲ. ಅದು ಉಳಿಯಲ್ಲ, ಪೂರ ತರ್ಜುಮೆನೂ ಆಗಲ್ಲ. ಬೇರೆ ಬೇರೆ ಸಮಸ್ಯೆ ಇದೆ. ಆ ಕಾರಣಕ್ಕೆ ಅಟ್ಲೀಸ್ಟ್ ನಾನು ಮೊದಲಿನಿಂದ ಹೇಳ್ತಾ ಇರೋದು, ಮಿಸ್ಟರ್ ನಾಯಕ್, ಐ ಹ್ಯಾವ್ ಬೀನ್ ಟೆಲಿಂಗ್ ಅಟ್ಲೀಸ್ಟ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ, ಅದನ್ನಾದರೂ ಕನ್ನಡದಲ್ಲಿ ಕೊಡ್ಬೇಕು. ನಾವು ಬೇರೆದು ಹೊಕ್ಕೊಳ್ಳಿ, ಪೂರ ಜಜ್ಮೆಂಟು ಯಾರು ಓದಲ್ಲ. ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ಲಾಯರ್ಸ್ ವಿಲ್ ರೀಡ್. ಬರೀ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅನ್ನ ನಿಮ್ಗೆ ರಿಲೀಫ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ನಿಮ್ಗೆ ರಿಲೀಫ್ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಕೊಂಡು ಅವನು ಆ ಜಜ್ಮೆಂಟ್ ಹಿಡ್ಕೊಂಡು ಮತ್ತೆ ಲಾಯರ್ ಹತ್ತಿಗೆ ಹೋಗ್ಬೇಕು, ಅಥವಾ ಇಂಗ್ಲಿಷ್ ಬಂದೋರ್ ಹತ್ತಿಗೆ ಹೋಗ್ಬೇಕು. ಅದು ಒಂದು ಸಮಸ್ಯೆ. ಅದು ಒಂದು ಇದೆ. ಅದು ಒಂದು ಅನುಕೂಲ ಆಗಿದೆ. ಹಾಕಿದ ತಕ್ಷಣ ನಿಮಗೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಸಿಕ್ಬಿಡ್ತದೆ. ಅಕ್ಯುರೇಟ್ ಇಲ್ಲಿದ್ರು ಒಂದು ಹಂತದ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಸಿಗತ್ತೆ. ಥ್ಯಾಂಕ್ ಯು. ಎಲ್ಲರೂ ಮಾಡೋದು, ನಾವು ಒಬ್ಬರೇ ಮಾಡೋದಲ್ಲ. ಕನ್ನಡದಲ್ಲಿ ವಾದ ಮಾಡಿದರೆ ಖುಷಿ ಪಡ್ತೇವೆ ನಾವು. ನಮ್ಗೆ ನ್ಯಾಯಮೂರ್ತಿ ವೆಂಕಟೇಶ್ ಅವರು ಇದ್ರು, ND ವೆಂಕಟೇಶ್ ಅವರು ಹೇಳ್ತಿದ್ರು, ಕನ್ನಡದಲ್ಲಿ 4 ಸುಂದರವಾದ ಮಾತುಗಳನ್ನು ಹೇಳ್ಬಿಡಪ್ಪ ಅಂತ ಹೇಳ್ತಿದ್ರು ಅವರು. ಹಿಂಗದು. ಎನಿವೆ ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಂಗ್ಲಿಷ್ ಅಂತ ಬರೆದು ಬಿಟ್ಟಾರೆ. ಎನಿವೆ ಆಲ್ ನೆಕ್ಸ್ಟ್. Steps taken. Steps are said to have been taken. First of raised to verify and act upon. Next. Infectious. Counsel for the petitioner has moved a memo telling the court that matter has become infectious and accordingly to be disposed of. Memo reads as an no objection from the other side. First off, ordered accordingly and disposed of. RP is disposed of. Next. Yes, Prashant Kumar, ಏನಿದೆ? Yes, Mr. Holla, I asked the last time. Once trustee is registered under the provisions of the Indian Trusts Act 1882, whether argument that it is a trust that would answer the requirement of section 92 of CPC is permissible or not?
Family property na ಒಂದು trust ಮಾಡ್ಕೊಂಡ್ರು ಅವರು. One of them, my lord, both persons, all of them are not parties to it. Therefore, my lord, it could not have been created. One. Second, they did not pay the court fee, stamp duty, and then ultimately all of them, they went and said, no, we don't want to pay the stamp duty. We are not interested in having the trust. After, my lord, another 10 years, this gentleman goes and pays the stamp duty. This is something much more than what we cite. And then says now.
The same trustee.
Settlement deed.
Hey, let us see how argue. They are in reply now. They have made our notes, na? Duty, deficit duty is paid by one of them.
And both, the stamp duty paid, these were not,
That is section 160. One 168 of petition copy. Other 168, yeah, court action, objection statement. ಅಲ್ಲ 168 ಇರೋದು ಪಿಟಿಷನ್ ಕಾಪಿದಲ್ಲಿ OS ಹಾಕಿದ ಬಗ್ಗೆ ಬೆಂಗಳೂರು ಟೆಕ್ನಿಕಲ್ ಫೌಂಡೇಶನ್ ಟ್ರಸ್ಟ್ ಎಟ್ಸೆಟ್ರಾ ಅದಾ? ಹಾ ಕೊಡಿ. ಹಾ ಹಾ 138. One 68.
after 16 years, if you are also seeing your appeal get on the date.
Section 33 ಅಡಿಯಲ್ಲಿ this is 10/7/2001.
The petition of the trustee.
Correct. True. ಗೊತ್ತಾಯ್ತು. ಹಾ
Trustee record is dated.
2001. 4/5/2001. One two zero na?
70.
170 is 10/7/2001. This is on Vyavastha Patra. Some of the properties which they say belong to trust, they are comprised in this family arrangement.
Children, including the person who are managing, so-called person who was executed. Ultimately,
Deficit is paid.
as not a Vyavastha settlement deal. Custodial money.
Yes. Uh, 18969. In the name of Srimati Lakshmamma. On behalf of the joint family. Ah.
On account of various factors, there's some
Group.
because
18789. 1368 of 81. That resulted into compromise.
as per the compromise, the grant public property survey number 2, subject to the condition, Muniappa shall pay 50% of the sale cost for the JN. JN of past not leaving behind him his sons and daughters over this sharing the scheduled power.
And they had filed a suit for partition.
And separate possession lot OS 7551 on the file for Bangalore. Against Muniappa and his heirs. And the intervention of the Lord Delvision was not intended in the compromise.
Yes.
Then the Lord. Name number 9.
Yes.
Muniappa converted 2 acres of residential land and 2 acres 22 acres of industrial property. During the lifetime of Muniappa, his children were, that is, sale number 11, Vijay Kumar, Prithviraj and Chandraprabha, and Murali, represented by his power of attorney.
They executed the trust deed.
Trust deed was executed under the influence of Ravishankar. Executors were misrepresented as they were unaware of about the contents. One of them is not even a party.
R3.
Respond number 3.
R3. Correct.
Here. He said, Lord, he is not a party to this so-called the state of the settlement deed or whatever. Then, Lord,
10/7/2003 undervaluation was made good.
discovering the partition deed was cancelled by cancellation the partition deed dated 8/7. Registered as document number 1940 of 2007. Reaching the family property for Muniappa executed.
Release deed.
Then Lord, the suit miscellaneous case was filed for rendition of account.
What happened to that?
On 17/8/2024.
ಅದೇ ಲೋಕ ಅದಾಲತ್ ಮುಂದೆ ಸೆಟ್ಲ್ ಆಯ್ತಾ?
After the lapse of 16 years from the date of presentation, the alleged trustee, Ravi Shankar Lord, without the knowledge of the owner, stated as his family.
Yes.
There is a suit, another suit filed by the other daughters of the leader for partition, case number 5939. Declaration of the trustee, in law, etc. Parties do not settle the dispute before the local law. That is not the same number 20.
Itself is the matter of challenge here.
But is pending. Question is not whether the third party can not challenge. That is one aspect. Second is not, you cannot be, all the parties not the so-called not the settlement or whatever it is, are not parties. Whether or not that document is a valid document. Thirdly, not whether a document not which is stamped as not settlement deed, not as a trustee, what would be? Another.
So that settlement was in furtherance of the trust deed itself,
Settlement deed as a stamp copy.
stamp duty.
Stamp duty was as a settlement deed, not as a trustee. Which your worship saw at page 176. So, what is now not challenged is, and he has filed section 92. One of them, one section 92 for the trial court.
It is still pending. Filed by whom? Hello, file ಮಾಡ್ತೀವಿ ಅಂತ. Not pending. What was he, the petitioner in that?
He was not there at all.
He was not there at all.
He was present only there.
See, he wants to espouse the cause of beneficiaries of the trust, saying that trust is 92 trust at that character.
Question is not whether
He can maintain that.
that's me. It's a family property, admitted. Family plot, all of them are not coming.
And he is not a member of
He
the.
is not a member. They are saying that there was a misrepresentation. Other one suit is not filed by the daughter. Adu ended in that compromise that they want.
Correct, pursuant to which partition deed happened. You, Mr. Rao, appears for whom? Yeah.
I represent him, and I am also the signatory to the compromise.
You are a signatory to the compromise petition. You sail with the petitioner or resist it?
Both that as was constituted in compared to 2001. At no point of time, any of them, this was carried on. No bank accounts were opened because the document itself was not listed. It was only listed subsequently in 2017. And
Which trust deed? That is stamp duty. But trust was registered as.
It was not listed, it was pending at meeting.
ಯಾವಾಗ registration ಆಯ್ತು?
Registration, Article 2017. After the stamp duty was.
Till then registration did not happen.
Pending at meeting. Stamp duty did not agree with all.
Where, but it was registered.
It was stated for
Registration,
but it was never released.
Not registered.
Because of the objection related to stamp.
all right. What is the status of transaction comprised in a conveyance which is presented for registration, but registration is pending? What is its status?
Should be because of the non-registration.
It does not bring into existence intended transaction.
We could not really have, no activities were carried out. Absolutely no activities were carried out. Instead of anybody claiming to be the beneficiary, the trust doesn't arise at all. Because at no point of time, any of the activities of the trust were ever started. That is a-
So the very version that there is a trust and it is in operation, there are beneficiaries of the trust whose interest is let down. This we cannot treat ಅಂತ ನೀವು ಹೇಳೋದೇನು?
because at no point of time ever came to this means that body and never carried out carried exactly.
When-
Everybody are taking the patent as that.
Actually, when the registration was accomplished,
Stamp duty was paid.
Show that. No, that was, it only says stamp duty was, it does not say anything beyond section 33.
Beyond.
Correct.
But I thought the document was released after adjudicating and all that. Only in 2007, during this period, nothing happened. Even thereafter, nothing happened. No institutions were started, no education, no funds were utilized, no bank accounts were opened, nothing happened.
Brother, any account was opened? Any bank account was opened in the name of the trust? Not owned. Any beneficiaries are given any benefit out of the trust property? Though you have not stated, you are asking, you dehorse your pleadings now. Whether at any point of time, any benefit accrued as such to the trustees, to the beneficiaries of the trust. No, we cannot go on like that. Somewhere we have to draw the line. No. Not registered, reserved for. But my question to Halla remains unanswered. Not like that. It's only, if a trustee is registered under the 1882 Act, because the preamble to the 82 Act says law relating to private trust. There are at least 2-3 judgments also. One is Narayan Bhale Rao versus so and so, Subhash Chandra Bose versus so and so, old one. There is B.G. Tilak versus so and so. So many judgments which say trust. In the light of that, some judgment has been Justice Rengne of Bombay High Court says, if a trust is registered under the 1882 Act, a high presumption arises that it is a private trust only. One Bombay High Court judge. How our High Court has treated this matter, I also was very busy. I could not examine. Anyway, one judgment, that question arises in this case. Very. Yeah. Correct. No, once it is registered as a private trust, even then, argument to the contrary is available. ಅಂತ ಯಾವ ಜಜ್ಮೆಂಟ್ ಹೇಳಿದೆ ಮತ್ತೆ ಅದನ್ನ ಕೇಳಿ ಅದು ನೀವು ಹೇಳುವಂಥದ್ದು ಅದು ಮಾಡೋದು ಬಂದೇ ಬರ್ತದೆ. ಚಾರಿಟೇಬಲ್ ಟ್ರಸ್ಟ್, ನಾಟ್ ಚಾರಿಟೇಬಲ್ ಟ್ರಸ್ಟ್, ದೇರ್ ಕ್ಯಾನ್ ಬಿ ಪ್ರೈವೇಟ್ ಚಾರಿಟೇಬಲ್ ಟ್ರಸ್ಟ್ ಆಲ್ಸೋ. ದ 92 ಅಲ್ಲಿ ಮಾಡೋದು ಅವರು ಪಬ್ಲಿಕ್ ಚಾರಿಟೇಬಲ್ ಟ್ರಸ್ಟ್.
Trust which is registered, I'm not taking the word as public contract. Once it is registered as a trust, whether the issue of saying whether it's void by mutual consent by the parties, whether that is possible.
Whether such question is permissible to you to raise is the question. 100 odd questions may arise in every case. But if right person, Apex Court said, Delhi High Court said, millions of questions may arise before the court, but court will stay away unless right person in right proceedings raises those questions. What is your locus ankondu one prashne ide. That's what they have argued other day. Anyway, it requires consideration. Let us see. I have to read again. Much of that I have forgotten. Yes. Dwarkanath. You appear for Dwarkanath. We can't, we are not in the habit of waiting for any advocate like that. Because how many times I should adjourn? Nauseating. Sorry. Heard and reserved. If you want to say something, give it in writing. ನೋಡಿ 1, 2 and 4 ಅಂತ ಮಾಡ್ಬೇಕು. Third result. Anything? Respondent 3 is not the signatory. Yes, that we have not said. Other day, ಕೊಡಿ. ಅದು ಹೆಸರು ಬರ್ಕೊಳ್ಳಿ, ಯಾರ all. No interest to litigate at all because of apex court judgment. That's your stand. All, let us see.
Petitioners 1 to 3 are not parties to OSM. What is their interest?
You are respond 3, non-signatory to the trust deed. All. Yeah.
Petitioners are not parties to this, to the OSM.
All. Okay. Office objection as to implement of office objection as to array of parties is overruled. All. In Mukherjee's law of trust, there are such judgments. ಅದಾಗಲ್ಲ, ಅದು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಬೇಕಾಗ್ತದೆ. ಅದು ಪ್ರೈವೇಟ್ ಟ್ರಸ್ಟ್ ಆಗಿ ರಿಜಿಸ್ಟರ್ ಆದಾಗ is it permissible to anyone to say that it is a public trust? Number 1. Or can a private trust so registered under the 1882 Act can undergo metamorphosis into a public trust? This one. How that metamorphosis happens? What is the normative basis? That's what was. ಒಂದು ವಾರದಲ್ಲಿ ಕೊಡಿ. Anyway, in vacation, I want to study law of trust also. I want to again study that. I'll write some judgment. That's no. Oh, yeah, I am much more student. I am a kindergarten student. Very good. Thanks. Yes, it is me.
Serial number. I appear for respond in this case, Miller. This was ordered to be posted after the disposal of the SLP before the Supreme Court and also the MFA.
Pending ಇದೆ ಏನೋ SLP.
ಇಲ್ಲ, dispose ಆಗಿದೆ. I have filed the judgment copy also.
ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಇಲ್ಲ.
ಆರ್ಡರ್ ಡಿಸ್ಪೋಸಲ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ?
ಇದೆ, disposal order ಇದೆ. It has been allowed. And the MFA has also been remanded, which has been set aside by the Honorable Supreme Court.
ಏನು? ತೋರಿಸಿ. ಅಪೀಲ್ ಈಸ್ ಅಲೋಡ್ ಅಂತ ಇದೆ ನೋಡಿ, ತೋರಿಸಿ, ಓದಿ ಆರ್ಡರ್. ರಿವ್ಯೂ ಪಿಟಿಷನ್, ಅಲ್ಲಿ ಒಂದು ರಿವ್ಯೂ ಪಿಟಿಷನ್. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ, ಸೌಕರ್ಯ ಕಾಪಿ ಕೊಡಿ. ಅದು ಕಳಿಸ್ಬೇಕು ಮತ್ತೆ ಟೆಸ್ಟ್ ಒಂದು ಪೋಸ್ಟ್ ನಲ್ಲಿ ಕಳಿಸಿ. ಅವರು ನೋಡ್ಬೇಕಲ್ಲ, ನೋಡೋದು ಬೇಡವಾ ಇದನ್ನೆಲ್ಲ? ಮಿಸ್ಟರ್ ಸಾಹುಕಾರ ಒಂದ್ಸರಿ ನೋಡ್ಕೊಳ್ರಿ ಅದನ್ನ.
Please.
This matter in the first week of February 2025, since it is said that the matter is pending before the apex court of the country in review. Okay. Next. Yes, Mr. Kamath, ಏನಿದೆ? ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗತ್ತಾ? Parties together, counsel for the parties together submit that they are exploring the possibility of amicable settlement. Huh? Amicable settlement try ಮಾಡ್ತೀರಾ? Mediation refer ಮಾಡೋಣ? Settlement, and therefore matter be referred for mediation. Bangalore Mediation Center. First, I agree. First, ordered accordingly and call this matter. Ordered accordingly. First, parties to appear before the center. Yavattu? Next week, nal. Appear before the mediation center on 19/12 at 11 AM and seek instructions at the hands of the center. 3 PM or at 3 PM and seek instructions at the hands of the center. Okay. Next. Mediation center. ಎಲ್ಲದರಲ್ಲಿ
Interim orders may be continued.
Of petition cause being indivisible for non-taking of steps in respect of R19.
No. Interim order to continue till then. Till report of the center comes. Seven. Nagaraj Hegde. Form number 7A, that is 77A. On ಮಾಡಿಕೊಳ್ಳಿ.
Lord, on the ground, my lord, my father has availed the remedy by filing an application under form number 7.
Yes.
Lord, I have produced the document, the endorsement issued by the revenue authorities, my lord. My specific contention from beginning, my lord, even before the appellate tribunal and before this honorable court, my lord, in the writ petition, no application had been filed by my father.
But I have said your
Yes, my
father
lord.
had filed
That is the
application.
statement which was given during the course of the inquiry by the petitioner, that, my lord, my father has filed an application, the same is pending for consideration, no order has been passed. That is not true, my lord. He is under the assumption that application would have been filed, but endorsement says, my lord, clearly, no application is filed under form number 7.
See, form 7A
Yes, ma'am.
is maintainable only where form 7 was not filed.
Not filed. Form number 7 not filed, ma'am.
In this case, not filed.
Yes, ma'am, not filed. It is a document issue.
You know what he say? We proceeded on the assumption because the records, somewhere it is said, that was your stand also. ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. Learned counsel for the review petitioner submits that the judgment now put in review has been structured on the premise that petitioner's father had filed application in form 7 under section 48 capital A of KLR Act 1961 and Reforms Act 61. When no such application was filed. First, the AGA to verify and come back. All this matters.
The review petition you filed.
ಏನಂತ?
Argument in the writ petition is not placed this.
Anyway, now he has produced it, na? Suppose form 7 ಹಾಕಿರ್ಲಿದ್ರೆ, division bench says, form 7A is maintainable. Form 7 for grant of occupancy. Form 7A for grant of land itself, because section reads that way. That's how myself and Varale Sahab held, affirmed by Apex Court also. Therefore, you have to verify whether such application was filed or not. All right. Call in the last week of January.
Obliged.
Okay. Delay condone ಮಾಡೋಣಂತ. ನೋಡಮ್ಮ, review petition is filed after booking a short delay of 44 days. First, an application seeking condonation thereof is also moved and it is supported by affidavit. First, no objections are filed to the same, comma, rightly. First, next part, delay being short and explanation being plausible, comma, the same is condoned. Application allowed, same is condoned. Okay. ಆಗಿಲ್ಲ ಈಗ all right, AGA for Arun and all. Yes. Yes.
Lord, this matter, party in person, respond number one,
Yes.
requested me to file wakalat. I may be given time,
But see,
and in the meanwhile,
Secretary appears
yes,
for party in person. Our respondent,
respond number two is dead, and they have to take steps so far as.
second respondent having died, petitioner to take steps in respect of him. Yes, call in third week of January. Next. Yes,
I am for the petitioner, please, Your Honor.
yes, sir.
Before proceeding with the case,
ಭಾಳ ಸಲ ಆಗಿದೆ ಇದು ನಮಗೆ ಮುಜುಗರ ಆಗ್ತದೆ. We can't make that request. Many times, last time also we said like that. ಮಾಡ್ಲಿ, argument ಮಾಡ್ಲಿ.
My
ನೀವು
apologies.
ಮೆಸೇಜ್. ನೋಡೋಣ ಎಷ್ಟೊತ್ತಕ್ಕಾಗತ್ತೆ ನೋಡು.
Your
Yes.
Honors, before proceeding on the merits of the case, I have a submission to make. We deserve respect in the court of law. Advocates should not be humiliated by the court. At times, we feel humiliated by this very court.
Give instance.
I'll give an instance.
Yes,
I was also a judge of this court.
correct,
I'm senior to you.
correct.
I'm 71 years old.
Yes,
In a proceeding, a particular provision was supposed to be quoted before the court. That is 168 of the Companies Act.
right. Anyway, tell.
I was prompted by the public prosecutor or somebody sitting over there that it is 168 because I was fumbling to find out that particular provision. My assisting counsel wrote a book and said that it is 168. I pointed out that it is 168. What your honors did was, you are not being properly assisted. Go to the library and read it and come.
To you,
You said it to me, sir.
I'm really sorry. I cannot say like that to you because your father was my guru.
I spent sleepless nights for weeks together.
I'm really sorry if I said it to you. Definitely not to you. It can never happen to you, I assure you. Really,
I was
it can
wondering,
never be to you because you are treated as one of the stalwarts of criminal law. I tell you the truth. To you, I can never just see the book which I have presented to you and what I have written in the first page of that book. I really am sorry. It can never be to you.
in fact,
I tell this truth.
in fact,
I touch my heart and tell you, it cannot be to you.
in fact, when I resigned and came, we met in the corridor and your lordships expressed that there is a Buddha in every teacher.
I said, and what I have written in your book, you have that book, I gave that book to you. What I have written in the first page of the book, kindly see that. If you write, if at all you write your autobiography, kindly reproduce my words. I am really sorry. It can never be to you. I do not know how this miscommunication happened.
It was lingering,
Who can tell this to you?
it was
Let
lingering
me alone. Who can tell this to you wrongly
past
like that?
since past 3-4 months. It was lingering in my head.
Hey, really, I'm
I
very
felt,
sorry. Really, I'm very sorry. Don't feel that it was never intended to you at all. I always tell the library, the young people, I thought you should have, how I can talk to you like that, Mr. Nayak, you should not say all these
my
things.
colleague.
Really, I tell you,
He was
no,
just-
no. Kindly do not say that. Kindly do not say that. Who can tell it to you?
We shall forget it, please.
Really, I feel so disturbed. How can I tell this to you?
Sleepless
Simple.
nights, please, Your Honor.
Very sorry.
For weeks together.
Why you should not call me over the phone? Sorry, you said like that. Can you say like that? I would have clarified it there itself. How can I say that to you? Please understand this. This much I will say. I will not say more than that. Not me. How can anybody tell you like that? But I always tell the youngsters, go and sit in the library. Maybe that you have mistaken that I have told it to you. It can never be. Perhaps you can tell it to me, but I cannot tell it that to you. Please forget that.
Self-
Kindly
which-
forget that. No, no. First you should tell me that you have forgotten that. Otherwise it hurts me. That's the reason.
I'll forget it.
Yes, yes, grateful. I am grateful to you. I tell the youngster to go and sit in the library because my senior, Mr. BP Holla, used to tell me, don't go like this. ಏನದು 10 ಸಾರಿ ಹೊರಗೆ ಹೋಗೋದು 10 ಸಾರಿ ಒಳಗೆ ಕೊಡೋದು ಯಾವಾಗೆ ಬರೋದು ನಿನಗೆ ವಿದ್ಯೆ. This I tell to youngster, but certainly I swear I never intend, if I tell that to many people is another thing. To you I cannot.
ಓ, ಯಾವ ಮೂಡಲ್ಲಿ ಇದ್ರು ಅವತ್ತಿನ ದಿವಸ?
ಇಲ್ಲ ನಿಮ್ಗೆ ಅನ್ಲಿಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಎಂತ ಮೂಡಿದ್ರು ನಿಮ್ಗೆ ಅನ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. Really, I cannot be. ಏನೋ ಮೂಡ್ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗ್ತಾವ is correct. Even then I cannot tell it to you. Nobody can tell that to you. You are a tall member of the bar. Please, you forget that those words.
We shall forget
I will
it.
not say withdraw those words because that again will be a bad thing to say for a judge. But forget those words.
We shall forget it.
Really?
I forget it.
Really, really.
I forget it.
I cannot say that to a lawyer of your stage.
Your
Yes.
Honor, this is a review petition seeking review of an order passed by this honorable court
Yes.
dated 20th March 2017 in writ petition number 44069 to 44073 of 2012. The matter went to the Supreme Court on page number 1 of the paper book your lordship may kindly refer to. Paper book page number 1.
Yes.
It is submitted by Kiran Suri, learned senior counsel for the petitioner, that the High Court has erroneously opined that determination made by the trial court.
Mr. Naik, where are you reading?
Paper book ಹಾಕಿದ್ದೀನಿ. It is containing about 300 pages clear. 291 pages. Court officer ಇದು ನೋಡಿ RP.
Good.
Additional document ಅಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಇದೆ ಫಸ್ಟ್ ಹಾಕಿದ್ದು ಅದು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಫೈಲ್
Page number?
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೆಮೋ ಫಾರ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
Yes, page number?
Page number 1. You know what it?
Yes.
It is submitted that Kiran Suri, learned senior counsel for the petitioner, that the High Court has erroneously opined that determination made by the trial court had already been accepted in RFA number 183 of 1980, which fact is not in dispute. For the said determination was made in respect to the property belonging to the MUD, whereas in the present case, the petitioner was claiming substitution in respect of the ancestral property of the Mahant. Without going into anything, we grant liberty to the petitioner to file an application for the review within 4 weeks with all the details before the High Court. Learned counsel for the petitioner shall be at liberty to assist the court with authorities. If the application for review is filed within 4 weeks, hence the High Court shall entertain and decide the same on its own merits without throwing the same at the threshold on the ground of limitation. Needless to say, the High Court shall ascribe reasons while dealing with the application for review. If the petitioner becomes unsuccessful in the application for review, further liberty is granted to challenge the present order as well as the order passed in review. With the aforesaid liberty is given.
Which was the
order to be reviewed is on page number 3.
Justice Ramesh.
His Lordship Justice Ramesh order. This was an order challenging the order dated 1/9/2012, passed in OS number 17 of 1978. Para 4 of the order. These writ petitions are by the applicant in IA number 17, 18, 19 and 28 filed before the trial court to bring him on record. of the suit in OS number 17 of 78 as the legal representative of the deceased plaintiff, namely Mahant Sri Krishnanandagiri Goswami, by the impugned order dated 1/9/2012, the trial court has rejected the aforesaid applications and has allowed the application of respondent number 1 here by permitting him to come on record as legal representative of the deceased plaintiff. I have heard a learned counsel for appearing for the parties and perused the records. The trial court, on detailed consideration of the matter and by referring the previous proceedings between the parties, has held that the respondent number 1 herein is the legal representative of the original plaintiff and not the petitioner herein. It is relevant to refer to the following reasoning of the trial court in this behalf. On careful analysis of the evidence placed on record by the rival claimants at this stage, I would like to express that the orders passed in MSA number 89 of 88 and RFA number 183 of 80 are the final orders of the Honorable High Court of Karnataka. Here, pausing here for a moment. MSA number 89 of 98 was withdrawn.
What was the suit OS 150 of 1972?
150 of 1970, it was a suit for declaration and possession and also for the recovery of certain sums. Here in this finding that it is based upon MSA 89 of 88 on page number 265. 265, yeah, what is the fate of MSA may kindly be looked into. Relevant portion is on 266. Counsel for the appellant files a memo dated 11/1/1993 seeking permission for withdrawal of the original suit OS number 142 of 83 pending on the file of the second Mansif so and so. Then the permission is granted and it has been dismissed.
Who were you in that?
I am Bhishma Pitama, brother of Giri Goswami.
In OS number 142/83.
Krishnanandagiri Goswami is the original proprietor of the entire mutt and the properties in question. I am his only brother. He was unmarried. One Krishna Mohananandagiri Goswami comes and says that he is a disciple of Krishnanandagiri Goswami and he has been installed as a chela of that Swamiji. And as such, he claims to be the legal representative of Krishnanandagiri Goswami. That is the dispute between the parties.
Mr. Nayak, do you have plaint of that OS 142 of 83 with you?
143 of 83.
There are two suits.
Yes.
One is OS 17 of 1978. Another is OS 142 of 1983. Do you have the plaints of those two suits?
(142) is not produced, please. In additional documents, there is one more set of additional documents filed there. Even in that also 142 is not produced.
What is actually the dispute? Can you just succinctly tell that?
Krishnanandagiri Goswami
is your brother.
He was my brother. There is one Tripura Bhairavi Mutt in Kashi. A branch office is in Mysore. The branch office is looked after by Krishnananda Giri Goswami. The properties of the persons who were managing the trust were claimed to be the Mutt properties. And the matter went to the Supreme Court. Supreme Court said that only such of those properties which have been dedicated to the Mutt can be claimed to be the Mutt properties, not other properties. Because the persons who were managing the Mutt were doing toddy business and money lending business.
So they had source of income to acquire other properties.
They had source of income to acquire several properties. There is a judgment of the Honorable Supreme Court in that regard between the same parties.
What order was challenged before the learned single judge, Justice Ramesh?
Order dated
To
1919.
my knowledge, Mr. Naik, I am telling you, two applications were filed.
One was
to come on record. It's a rival claim. They accepted one application, rejected
the other application.
That order was put in.
That order was challenged. I made three applications totally. One for condonation of delay, one to come on record, one to treat me as a legal representative
of deceased.
The other one in an individual capacity to come on record. All four applications came to be rejected in OS number 17 of 1978. And those applications were a subject matter of challenge before the High Court in the writ petition. And in the writ petition, the court relies upon the orders which are already set aside and arrives at a conclusion that I am not a legal representative, whereas Krishna Mohanananda Giri Goswami is the Yella.
Who is that Swami? How he is related to your brother?
He is not really, he was a sari vendor. He came to look after the Bhishma Pitama because he was handicapped. And he says that he was installed as a Swamiji in the Mutt.
This order is between Krishnananda Giri
Goswami
and Guru Charana Prasad. Krishnananda Giri.
This is Guru Charana Prasad, the Supreme Court order.
That's right.
Para 9 of the order may kindly be looked into.
Where is their objection to your applications? Which page?
It's 17 and they not. On 30/6/2022, I filed a memo and the documents. In that we find the objections.
Page number?
Page number 33.
Mr. Nayak, you may oppose objection, the prayer of the other side to seek time, but you have to give me one adjournment. I could not go through the papers. I will read and come back.
Please.
I'll read and come back.
Really short time for this reason, my lord.
Anyway, many times it has come, very old matter.
Lord, I'll just request my lords to kindly also have a look at this.
No, I have not read the papers. The
La, la.
matters like this cannot be disposed of but by
La, la.
reading 2 pages.
No, I am only requesting my lords to also, Lord, peruse the objection. That's all. I'm not arguing today. Objections, my lord, there is already a suit where the rights are concluded. That is all that I want to bring it to the notice of the court. Lords may have it on any other day. I'm not, my lord, coming.
Just indicate which
Yes,
is the
my lord.
page.
That is why, my lord, please see, have a look at the statement of objection.
Do you dispute that Bhishma Pitamaha is a brother of the
No,
You do not dispute.
No, we don't dispute. All that we say is, my lord, this mutt, my lord, is a local mutt. Lot of properties were endowed in the name of the mutt.
No, but Apex Court says, para 4 which he read now.
That is, my lord, the main mutt in Kashi. That is different, my lord. That is the main mutt in Kashi. That does not, my lord, pertain to the branch mutt at Mysore. That is the main mutt at Kashi. There, my lord, there are some observations saying that, my lord, the Swamiji in his individual capacity had undertaken some money lending business. That is in relation to the main mutt at Kashi, my lord, not, my lord, the Mysore mutt.
Here again, we do toddy business and earn money business.
Now, there is a
Money lending business.
fully,
But this, Mr. Nayak, 1967 judgment,
Yes,
does it refer
way back
to?
in 1967, 68.
That's all right. Whether it refers to any property in Mysore mutt?
no.
Property in Mysore mutt has not been referred to. I am only relying upon this particular judgment to say that the properties of this particular mutt are not mutt properties. They are individual properties also, unless they are blended with the mutt properties as endowed.
Whether doctrine of blending applies to mutt also?
Obviously, it should.
Obviously?
It should.
No, I do not know. I am not of that view. But I am asking you, because it arises in your case, whether doctrine of blending applies to a mutt.
That is what is the finding of the Supreme
That
Court.
was in respect of a property, is what his version.
Here again,
It
we-
appears that way.
On record, we find.
There is a concluded suit, my lord, between us, where, my lord, this
One
property.
second.
Sorry.
Mr. Naik, kindly come to page 9, para 9 of your judgment.
In our view, the High Court fell into an error
In
in
holding
holding
that the
that the
observations of this court led to the conclusion that all the property belonged to the mutt because the evidence on the record did not expressly indicate which property belonged to the mutt and which did not. These are properties not of Mysore at all.
these are not properties. This is a branch of his. This is a branch of the head mutt.
Any pleading to that effect is taken?
There is
up?
a pleading.
Where is that?
There is no distinction between Kasi mutt and this mutt. Tripura Bhairavi mutt is only one. That is located in Kashi. It has got a branch over here. That is not in dispute at all.
No, he is disputing that.
No, he doesn't dispute in anywhere.
No, he said no. That there is no such branch at all.
No, with regard to the properties acquired by the Mysore mutt, his contention is that this judgment does not apply. In Mysore mutt,
It does not relate to Mysore properties. It does not refer to,
in
whether
Mysore,
it refers to one sentence about Mysore mutt.
there is
anywhere.
not even a single sentence in that regard in the Supreme Court judgment.
But you have taken up that contention.
I have taken up that contention.
Have you denied that contention?
Yes, my lord. There's a suit, my lord, in Mysore between us, which has gone in my favor. My lord, I represent the Shishya who is appointed by undertaking all ceremonies. There is a full-fledged suit. Judgment and decree has gone in my favor. Finding of the trial court is.
Show that. Show that.
Memo I have filed on 6/12/2022. Lord, page number 123, annexure R10.
Page number?
OS number, my lord,
32 of 1971.
No, my lord, 147 of 1995. Page number 123, annexure R10.
Agree. ಕೊಡಿ.
I can just, my lord, pass this on, my lord, for ready reference. ಇದು ಕೊಟ್ಟಿರಿ ಸರ್.
Page?
Page number 123, my lord, annexure R10. This is the judgment and decree in, my lord, 3 suits. Where, my lord, in the first suit, my lord, Bhishma Pitama, my lord, is the plaintiff. Page 123, please, my lord.
This is a subject matter of challenge in an RSA pending before this honorable court.
Exactly, but finding is in my favor by the
How
trial.
can
What
that
happened
be?
to the RSA?
They are pending.
It's pending.
ಮತ್ತೆ ಅದು ಡಿಸೈಡ್ ಆಗ್ಬೇಕಾಗುತ್ತೆ.
Pending, but my lord, prima facie, my lord, now the suit before the, my lord, Srirangpatna.
Any entry order is granted in RSA?
There is no entry order.
But anyway, issue is still pending.
Maybe, my lord, what I am trying to say, my lord, is there is no inter se dispute, my lord, in the Srirangpatna suit in relation to which the present matter rises, that is against a third party. Now, my lord, the question is, who should represent the deceased Swamiji? My lord, why should the third party be benefited in this dispute? This dispute in Srirangpatna, against which we have approached this honorable court, resulted in an order in my favor, in relation to which my learned senior friend has filed a review, is not an inter se dispute between us. It is with a third party. There are large
No,
tracts
he
of-
is brother of very pontiff.
Yes, brother, my lord, but the dispute is not whether, my lord, my right will my lord, prevail or his right will prevail. It is, my lord, in relation to a third party. Now the deceased Swamiji, my lord, has to be represented. I am representing it. Suppose I succeed, it is not going to become my property. It is a battle
What's
against.
property?
Yes, it is against a third party that we are fighting. Swamiji passes away. The dispute is who should come on record in place of the deceased Swamiji.
No, two things.
Yes, my lord.
No, Swamiji was the pontiff of Mutt.
Yes, please.
Pontiff died.
Yes, my lord.
Who should step into the steads of deceased pontiff is one question.
True, my lord. Correct.
A Swamiji had also other properties.
Yes, my lord.
That's what the Mr. Naik is saying. He can have other property. He's not a sannyasi.
No, he
It's
was
only-
sannyasi.
Where is that?
Sannyasi, my lord.
Where have you stayed? If he is sannyasi, how will he become pontiff?
He is called, my lord, Mahant of the Mutt.
Mahant is not a sannyasi. Mahant is held not a sannyasi. Mahant is broadly, he represents the managerial affairs of
That's
the
Institution.
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 That's how we have held
Yes.
in the Murugamat case.
Yes.
We have held that way. That has a form also now.
Yes,
So therefore, you can't say that he is sannyasi. Number one.
yes.
If he is a Mahant, which law prohibits the Mahant from acquiring his own property?
Lord, if he is a month, my lord, there is no restriction.
There is no restriction. Their case is, the Mutt had its properties,
True, my lord.
which in his capacity as Mahant he will manage. Mahant is my brother. Only if sannyasa takes place, this is what Sannyasa Upanishad says. Siddha, Arudha, Avaduta, Paramahamsa. 4 types of sannyasas, which law recognizes. Where he is a sannyasi, he cannot be the pontiff of the Mutt. He may be unmarried, he may be bachelor, these are other things. But once he says sannyasa, he cannot own property at all.
All his bonds, my lord.
Some means in Sanskrit, sampurna. He has to give up everything.
Yes,
Then it is virtually the pre-counsel treated in few cases. Sannyasa is civil death
yes, my lord.
for all
Because-
practice. That is not your case.
Lord, we have taken that contention earlier, my lord, but here what I am saying, my lord, Srirangpatna, the Swamiji, my lord, had filed a case against a third party. No, my lord, he is, according to us, an illegal squatter, my lord, enjoying the properties of the Mutt.
He is third party.
He is third party.
It's a judgment in personam.
Yes, my lord.
How it binds him?
No, my lord, the Srirangpatna matter, when the Swamiji passed away, the dispute is, my lord, who should represent his estate? That is all that is the dispute. Inter se dispute between both of us, my lord, is seized before this court in RSA. What I am submitting, my lord, is even if I succeed in that suit, it is only because my entire case is these are properties of the Mutt. I am the Shishya. And so therefore, even if I am not brought on record, I am not claiming any individual right in any property. Even if there is a decree in the Srirangpatna court, my lord, it will accrue to the mutt. It is not going to become my personal property.
Mr. Nayak, according to you, what are the properties which your brother had left? Brother, not pontiff,
Unless
which
there are
brother
about,
had left?
there are about 108 properties
Totally.
extending over about 250 acres of landed properties. All are acquired by the KIDP. Compensation is paid. I have taken the compensation. They are plus, and I have invested also.
Lord, all that I am submitting is this. Present review, my lord, arises out of a suit of the year 1977, which is pending in Srirangpatna. There, my lord, the suit was filed against a third party to seek his eviction because he is an unauthorized occupant. My lord, since the Swamiji passed away, my lord, now Shishya has been brought on record after an inquiry.
Where is that plaint?
They have themselves to be.
Give copy of the plaint.
See. OS number 17 of 78.
ಇಲ್ಲಿದೆ.
That is the.
ಇದರಲ್ಲಿ ಹಾಕಿದಿರಾ?
ಅಲ್ಲಿ ಕೌಂಟರ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ನಿಮ್ಮ ಕೌಂಟರ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಅವ್ರ ಕೌಂಟರ್ ಅಲ್ಲಿ ಇದೆ.
ಇದೆ. So therefore, my lord, it is against one.
Counter ಕೊಡಿ.
It is against one Mr. Cherian. My lord kindly sees the plaint. The point that I'm trying to make out is
The plaint was filed by pontiff himself.
Pontiff himself.
How he has described the property?
My lord, on Krishnananda Giri Goswami. Then my lord, now I have got the amended plaint.
No, that must be in respect of few properties.
Few properties only, my lord. This is against an illegal squatter over the property. Please see, the defendant is one Mr. Cherian in relation to some properties in Srirangpatna, where the suit is, my lord, for, my lord, delivery of possession of unauthorized occupation. What I am submitting before my lords is page 6. My lord, assuming I succeed in this, no harm is going to be caused to him because, my lord, that ultimate dispute is pending in an RSA. It will be decided. No, my lord, because of this difference.
ಯಾರ್ ಮುಂದಿದೆ RSA?
ಏನಲ್ಲಿ ಇಷ್ಟ ಆಗಿಲ್ಲ.
Single or?
Single, RSA is single.
RSA single.
Single.
I will request the Honorable Chief Justice to either allot it to me or allot these matters to the concerned
ಆಯ್ತು,
judge.
ಮಾಡು.
Because that will also have bearing
Yes, ma'am.
in the event he succeeds in the RSA.
No difficulty. All that I am requesting, my lord, is, my lord, my lords may make it clear, even if I succeed in the suit OS 17 or 78, that will ultimately be dependent on the
Plus-
outcome of the RSA. Let this quarter, my lord, not be benefited by our interstate
Plus-
dispute.
The very fact that I have been pursuing all these remedies in various courts goes to establish that I am not a sannyasi. I have filed suit for recovery of money.
Lord, why should?
No, Mr. Nayak,
I'm
what he is
doing
saying is,
Friday business.
no, Mr. Nayak, kindly appreciate. He says dispute is between brothers, the mutt and Redressal.
And if he is,
Third party is squatting on the
and if
property.
he is declared to be, say, this thing, please do not say in LR, would it not affect my right, please do not? In a third party dispute?
Which is what I am clarifying, my lord.
No, we'll protect it,
Yeah, protect it, my lord.
but let third party leave.
Yes, my lord, that is exactly.
So
what-
far as any property, if at all it remains, it will inure to your benefit only in the event you succeed. Please
Let-
appreciate this. What I say is, your dispute should not result into third party squatting on this property, which you say it is brother's property. After his demise, I have succeeded.
Fine.
Which he says it is mutt's property, therefore it should go to mutt. That we will decide. That
Yes.
question will not foreclose.
Even with regard to the property being a mud property or not, that is also in dispute.
Therefore, we will
Contention-
decide that, Mr.
But
Nayak.
contention is that it is not a mud property at all.
Correct. Therefore, whether property is a mutt property or your brother's property in his individual capacity, we will decide that. We are not foreclosing it. We will decide it. But his proposal appears to be sensible and legally tenable. What he says is, let not property go in the hands of the third party. Let it come, let it remain here. If you succeed, you will succeed to the estate.
Finding be kept in abeyance, please.
I feel like that.
Let the finding be kept in abeyance.
Not in abeyance, we'll keep it for consideration itself.
Let it be connected to the RSA, that will resolve the entire problem.
Let it be connected to the RSA, my lord, let it be sorted out, I am not coming in the way. Let this Mr. Cherian, my lord, who according to me is a rank trespasser, let me proceed against him, my lords may make it clear. whatever, my lord, decree is obtained in that is subject to the outcome of the decision which this court will take.
That may
How
help
can
you.
that happen, please, my lord?
My lord, I am doing
He
the work
being-
for him if he
He
succeeds.
being treated as an LR of Krishnanandagiri Goswami, please, my lord. Would that finding not go against me?
No, we'll
Even
make
in
it
the
now.
RS.
No,
He-
Mr. Naik. We will say, he will not, that, shall not press that finding
My
to
application,
defeat your rights.
my applications have been rejected.
No, that
My
is-
applications have been rejected. His application has been allowed.
That's
I
right.
wanted to
Therefore-
come on record.
Therefore, you are here, we understand that. What I am telling is, your RSA is pending. Correct?
True.
That's number one.
Pending, please. my lord.
There is no.
Your review petition is pending. But third party is enjoying the property. If we take that property back from him, the rights of the parties would be subject to outcome of this RP
Allow me,
and RSA.
allow me to take it back, please. my lord.
Huh?
I'll do it. Allow me to take it back. I'll take it back, please. my lord.
Now, as of now, he's holding the decree.
That is not, unless that is not the direction of the Supreme Court.
I'm
Supreme Court,
holding the decree.
Supreme Court says, please, my lord, the whole of it will have to be resolved.
Now, whole of it will decide, but I am unable to understand why you want to keep that third party, the property at the hands of the third party.
I am also not interested in
not
keeping him.
interested at all.
My only interest is to see
Get
that.
that property back,
Yes.
let it be as it is. Whoever will succeed to him, that property will go, but not to the third party.
That is the
Exactly,
reason this
Exactly.
particular finding,
Huh?
that he is an LR, please, my lord, let it also be kept in a base.
That's what.
And that's all.
Markoli. This review petition has a penumbra of other dispute which is allegedly pending in RSA number
Yeah, this
so and so
RSA number.
on the file of a coordinate bench of this court. First, the essential dispute
ಕೊಡ್ತೀನಿ.
between the parties is as to whether the subject property belongs to the mutt headed by brother of the review petitioner.
No, man. Headed
That's
by-
his case.
I am the brother.
Earlier. Now I am the Shishya.
He is a,
That itself is now, we'll decide that afterwards.
I am the,
Brother of the review petitioner in his capacity as the pontiff or in his individual capacity.
I am also dead, please.
You are
Brother is
also?
dead.
Dead, my lord.
LRs have come on record.
Anyway, Workal. Mr. Nayak, learned senior advocate appearing for the review petitioner, intervenes and tells that even brother is also dead. Both the brothers are dead.
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
And one brother is represented by the Shishya.
Shishya is not the brother.
No,
No, no, one
Shishya represents the mutt.
Yes, Shishya represents.
Ah, and one, and Mr. Naik says that the pontiff and the review petitioner having died, comma, pontiff's interest is represented by the so-called Shishya, and the brother's interest as such is represented by the review petitioner. Now now deceased and represented by the LRs.
LRs.
First, be that as it may. Next paragraph. Both the sides, having argued the matter for some time, tell us that the suit in OS number
17 of 78.
17 of 78 was between the pontiff and a third party in respect of one of the properties, and therefore one of the parties, first, one of the properties, first. Since the dispute has some complexity and case papers are at two places, that is review petition papers at the hands of this court and the appeal papers at the hands of other coordinate bench, comma, it is desirable that both the cases are heard and decided by the same bench. Same bench, comma, this or that. First, in that connection, the registry to seek necessary orders at the hands of learned Chief Justice and proceed. First, next paragraph. Mr. What I say is, understood. What I feel is,
Yes.
even that, let us see after these papers come, we will decide that. Because for any reason, if I permit that you should execute the decree against the third party,
Yes.
what way it will cast its shadow on his case, we do not know.
Which is why I'm requesting my lords to say, any fruits of this decree is ultimately subject to the pending RSA. Therefore, my lord,
But
it's
no,
simple
you
as
will,
this.
but you will take that property to yourself from the hands of that person by
Third
executing
party
decree.
spotter,
That decree is in a challenge now.
which decree, my lord?
The other decree in RSA
RSA decree is, my lord,
is independent of this.
independent of. So
This
there-
decree you want to execute and you will keep that property
But
for the
intact.
person who will succeed in this.
If I succeed,
Well,
Will record his contention.
17 of 78, past 49 years, nothing has happened. Now where is the great hurry? Let the matters be clubbed together and heard on merits, please.
No, question is,
49 years.
that's all right. How you will be aggrieved? You will be benefited.
Wallace,
You will be benefited
Wallace,
because
holding-
property will, unless you support the judgment debtor for whatever reason, I do not know.
Wallace, holding
How?
him as a legal representative, as a LR of the deceased, please, Manoj, by itself will hurt me. Wallace, would it not be a finding against me, please, Manoj?
No, we'll say that it will not against you, Mr.
It
Nayak.
is against me because I filed an application to treat me as an LR. He filed an application to treat him as an LR. Now he is treated as an LR and my application has been rejected.
Correct.
That is subject matter of challenge
That's all.
before the court.
Understood.
Now I
Now-
will be conceding virtually.
No, I
saying
we'll never treat you that you have considered on that. But on the other point, on the other hand, I am holding that you will be, if you succeed in this, you will get that property and straightaway he will place you in
The
into your
property,
hands.
the property issue does not come at all. The property is yet to be established that it is a mud property. Even if he is a sannyasi, installed in the mud, he doesn't get any property at all. It is not a mud property. It is my brother's property.
Correct.
How can he take possession of it, please? Manoj?
No, otherwise it will be with the third party only.
It is my brother's property. Let it go.
No, Mr. Naik.
Plus, I
that,
would say that it is my brother's property. It is not mud property at all.
No, that
That is what
point
Supreme
is,
Court has said, please, Manoj.
where?
Where in this judgment?
No, it does not refer to
It is
that. property.
blended.
No.
Malas, all along my contention is that they are not mud properties, they are my brother's properties.
Mr.
My
Naik,
brother was carrying on toddy business.
please,
A sannyasi would not
Mr.
carry on
Naik.
toddy business.
Mr. Naik, please appreciate. This judgment does not speak one word about Mysore. or
Malas,
this
my
property.
pleadings are,
One thing.
my pleadings are to the effect that Malas, I was carrying on toddy business. A sannyasi would not carry on toddy business at all, please, Manoj.
That's all.
He would not be indulging in money lending business. It was all his personal property, not mud properties. So that being the position, please, Lord, this order hurts me.
Mr. Nayak, appearing for the review petitioner, vehemently opposes the execution of decree,
The prosecution of this
the prosecution of the suit in OS number
17 of 78.
17 of 78, saying that in the event decree is passed in favor of the other side, that is Shishya, representing the pontiff, the interest of his client will be affected. First, I do not agree with this proposition. First, in any way, decree is not going to be passed in a day or two. What happens is the trial of the suit will go on, but no decree shall be passed. No decree shall be passed.
Allah, that order is already there,
Which order?
saying that no decree shall be passed.
Yes, there. But all right, we'll repeat it. The apprehension is if decree passes and you take the property, I will have many other problems, sir. Anyway, ಡಿಗ್ರಿ ಬಿ ನಾಟ್ ಪಾಸ್ಟ್. ಟ್ರಯಲ್ ಮಾಡಿಕೊಳ್ಳಿ.
ಅಲ್ಲ ಟ್ರಯಲ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ, ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ, ಅದು
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಡಿಗ್ರಿ ಮಾಡಂಗಿಲ್ಲ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
Then what he says is correct. Then he will not pass all. There is one aspect.
ಅಲ್ಲ
If
only thing
I,
is, my lord,
no, it is not that simple. Recall that. Then he is right. Suppose
yes,
you will get the decree, you will execute that property.
yes,
To that extent, you become rich and you will use that your riches to fight his battle.
lord.
Obvious, quite obvious, because and number two, once you get that property, you will go on enjoying that
Let
property.
me put the other picture before my lords. My lord,
ಎಲ್ಲ.
the
ಆಗ್ಲಿ ಎರಡು ಬರ್ಲಿ, ಏನ್ ಕಳ್ಕೊಳೋದಿಲ್ಲ. Then I was under impression, still it is going on that way. And let us see, nothing, recall that. First part on the. So RSA and the petition.
Please.
And don't feel bad. It can, yes, I felt so bad actually. You should have called me at least. You should. Never I will speak that way to you.
Forget it.
Really, never I speak that way. To juniors, yes, I tell because they come without preparation to this court as if they are coming to some chowdhury, which I will not tolerate. I will put them on terms. They should spend time in the library. Judges also spend time. I spend lot of time in my own library, but I can never speak those words to you. This you should simply, really, I feel hurt because unnecessarily you felt bad. And you should have told me. You said, for anything you can call me and for this you will not call me. What is this, Mr. Nayak? You should have told me, I am hurt, be your word. Straight away I would have said, I would have apologized in the open court itself. What is this you are saying?
I should have done it.
Don't feel bad. Really, I feel very bad. I felt very bad. Never I will say that to you. Yes. ಬರಲಿ, ಎರಡು ಬರ್ರಿ. RSA ಮತ್ತು ಅದು ಎರಡು.
grateful.
ನೋಡ್ರಿ, ಅವ್ರು 4 ತಿಂಗಳು ಸಫರ್ ಆಗ್ಯಾರಂತ ನೋಡ್ರಿ. ನಂಗೆ ಹೇಳೋದು ಬೇಡವಾ ಒಂದು ಮಾತು. I felt so bad because I hold him in very high esteem. And I should also tell, he had helped me. He had helped me enormously. His father had helped me. His father was a great figure. He was a great figure. Felt really felt bad. ಏನೋ ಒಂದ್ಸಾರಿ ಮಾತು ಹೇಳ್ತೀವಿ, ಅದನ್ನ ಇವ್ರಿಗೆ ಇಟ್ಕೊಂಡು ಹೇಳಲ್ಲ ನಾವು. ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ಲಾವಿಶ್ ಆಗಿ ಏನೋ ಮಾತಾಡ್ತೀವಿ ಅನ್ನೋದು ಬಿಟ್ರೆ, never I say, but I insist. Everybody should come with preparation.
ಅದು correct.
Everybody should come with preparation so that we can save time.
Public time.
Public time.
Ultimately.
But I hold Nayak in a
ಇಲ್ಲ,
very
ಇಲ್ಲ.
great esteem.
ಏನು
I
ಮಾಡ್ಲಿಲ್ಲ.
can never speak to him like that. I felt very bad. ಪಾಪ ಅಷ್ಟು ಹರ್ಟ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ಫೋನ್ ಮಾಡಿ ನಂಗೆ ಹೇಳೋದು ಬೇಡವಾ, ಹಿಂಗಂದ್ರೆ ನೀವು ಕೋರ್ಟ್ನಲ್ಲಿ ಯಾಕಂದ್ರೆ ಹಿಂಗೆ ಅನ್ಕೊಂಡು ನಂಗೆ ಬೈಯೋದು ಬೇಡವಾ? ಐ ವುಡ್ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಸರ್ ಹಂಗಂದಿಲ್ಲ, ನೀವೆಲ್ಲ ತಪ್ಪು ತಿಳ್ಕೊಂಡು. ಕೆಟ್ಟ ಹರ್ಟ್ ಮಾಡ್ಕೊಂಡಾರ ಅವರು, ಕೆಟ್ಟ ಅನ್ಸ್ಕೊಂಡಾರ ಅವರು. ಅದರ್ವೈಸ್ ವಿಲ್ ನಾಟ್ ಸೇ ದಟ್ ವೇ.
I know.
ಹರ್ಟ್ ಆಗ್ಯಾರ ಅವರು.
I know.
ಯಾಕೆ ನೋಡ್ರಿ ಹಿಂಗೆ ಮಿಸ್ಕಮ್ಯುನಿಕೇಶನ್ ಆಗ್ತದೆ. I never intend those words. ನೀವು ಲೈಬ್ರರಿಗೆ ಹೋಗಿ ಓದ್ಕೊಂಬರಿ ಅಂತ ಅನ್ಕೊಂಡು ನಾವು ಯಾರಿಗಾರ ಹೇಳೋದಿದೆಯಾ? ಏನೋ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇರ್ತಾರೆ, ಹೋಗಿ ಸ್ಪೆಂಡ್ ಮಾಡ್ರಿ ಟೈಮ್ ಅಂತ ಹೇಳ್ತೀವಿ ನಾವು. Otherwise we will not say that. Yes.
In this, my lord, there are two things, my lord, that 3884 iddu.
The second writ petition.
Second
you are
writ petition.
speaking of.
There is one more aspect, my lord, which I had to tell your lordships.
Padi.
The notification was issued.
My lords, one humble submission, I'm sorry to interrupt. If learned senior is continuing, I have no problem.
ಅವ್ರು ಒಂದ್ ಎರಡು ಪಾಯಿಂಟ್ ಆಡ್ ಮಾಡ್ತೀವಿ.
Mr. Raghavan, unfortunately, he is stuck in the New Delhi in one matter. So I am humbly seeking a small accommodation for his
My lord,
reply.
what happens is,
ಅಲ್ಲಿ ಹೆಂಗೆ ನಾನು
ಯಾವ್ದಾರ ಡೇಟ್
ಎಲ್ಲಾದ್ರೂ ಒಂದ್ಸರಿ ನಂಗೆ ಬಿಡ್ಬೇಕು ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀಲಿಕ್ಕೆ.
ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು, my lord, what has happened, I must tell your lordships. 79 acres, my lord, the government has taken, my lord, 300 acres. Writ petition, my lord, directed them to hand over possession. Writ appeal, dismiss. Review petition, SLP dismiss. Review petition before the Supreme Court, dismiss. Review petition again, my lord, before single judge, dismiss. Clarification, dismiss. 80 ಎಕರೆನ ಹಂಗೆ 90 ಎಕರೆನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಮಲಾಡ್ ದೇ ಆರ್ ಪರ್ಮಿಟಿಂಗ್ ಎನ್ಕ್ರೋಚರ್ಸ್. ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಇವತ್ತು ಬರ್ತಾ ಇದೆ ಅಂತ ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. 3 ವರ್ಷದಿಂದ ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ.
Learned senior has not come to, he's not in Bangalore only. That is
in fact, my learned friend senior had argued from New York, my lord, during vacation. Thamma court ಅಲ್ಲಿ. Therefore, it is nothing new for him.
I have already conveyed this in the morning itself to learned senior.
ನೀವು ಅವರಿಗೆ ಹೊರಡ್ರಿಗೆ ಫೋನ್ ಮಾಡೋದು
ಬೆಳಗ್ಗೆನೇ ಹೇಳಿ. I called the ER yesterday evening and I told him.
ಅವ್ರಿಬ್ರು ನಡುವೆ ಏನ್ ಮಾತಾಡಿರ್ತಾರೆ, ನಿಮ್ಗೆಲ್ಲ ಹೇಳ್ತಾರೆ, ನಮ್ಗೆಲ್ಲ ಹೇಳ್ತಾರೆ, ನಮ್ಗೆ ಹೇಳಲ್ಲ. But he will never let down client's interest.
Yes, my lord.
Whatever be the friendship. Anyway, yes, Mr. Valla,
What has happened is there is that 3884 ಅಲ್ಲಿ first notification, my lord, was published on 3/9/1994, preliminary notification.
4-1.
ಹೌದು, 4/1.
4-1 is dated.
My lord, published on, it is dated 2/9/1994. Published on 3/9/1994. Then final notification was, my lord, dated 10/10/1996.
You said that is beyond time ಅನ್ಕೊಂಡದ್ದು im contention.
ಹೌದು, ಅಲ್ಲ, ಎರಡಿತ್ತು. If your lordship recollects, I had, my lord, argued two things. ಒಂದು, award itself is beyond time ಅಂತ ಹೇಳಿ.
ಅದು 11 ಕೆಳಗಡೆ ಬರುವಂತದ್ದು.
ಇದು
very notification it. ಅಲ್ಲ, ಅದನ್ನು ಆರ್ಗ್ಯೂ ಮಾಡಿರಿ ನೀವು.
ಆಯ್ತು, ಅದನ್ನ ತಾವು ನೋಟ್ ಮಾಡಿದಿರಲ್ಲ ನನಗೆ.
ಮಾಡಿದ್ದೀನಿ. I don't forget at all. Really, I don't forget. You argued that also. Other point ಏನು?
ಅಷ್ಟೇ.
ಎರಡು ಹೇಳಿದ್ದೀನಿ. ಒಂದು, very passing of final notification.
ಇದು ಫಸ್ಟ್ ಅಲ್ಲ, ಇದು ಫಸ್ಟ್, ಯಾಕಂದ್ರೆ ಫಸ್ಟ್ ನೋಟಿಫಿಕೇಶನ್ ಹೋಯ್ತು.
ಕರೆಕ್ಟ್. ಹಂಗಾಗಿ ಮುಂದೆ ಹೋಗೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ.
ಬರೋದಿಲ್ಲ.
ಎರಡನೇದಾಗಿ
correct.
even award could not have been passed after that.
That's
lapsed because of 11A ಅನ್ನೋದು ನಿಮ್ contention.
And of course, ಆಮೇಲೆ abandonment of the very proposal for
proposal itself because they said that way.
Correct.
Before the other court.
ಇದಿಷ್ಟೇ.
Yes, Mr.
Additional Advocate General ಮಾಡಬೇಕು.
Kiran, you said that after Mr. Raghavan argues, he will argue.
Senior counsel I may have to adopt. Otherwise, I'm ready. I may take about 20 minutes. So my request is if senior counsel.
ನಮ್ಗೇನಿತ್ತು ಅಂದ್ರೆ ರಜೆಯಲ್ಲಿ ಸರಿ 4 ದಿವಸ ಎಕ್ಸ್ಟ್ರಾ ಡೇಸ್ ಇದೆ. ಹಂಗಾಗಿ ಒಂದ್ 2-3 ಮ್ಯಾಟರ್ಸ್ ಇದು ಎಲ್ಲ ಮುಗಿಸ್ಬೋಣ.
ಇಲ್ಲದೆ ಇದ್ರೆ, my lord, your lordships can do one thing. 317, my lord, that other matter 37140, that whether, my lord, 17, my lord, whether
section 66 ಇದೆಲ್ಲ
ಅದನ್ನ ಫಸ್ಟ್ ನೀವು ಮಾಡಿ, ಇದನ್ನ ಆಮೇಲೆ ಇನ್ನೊಂದು ದಿವಸ ಮಾಡಬಹುದು ಅಷ್ಟೇ. ಅದನ್ನ ತಾವು, because that is, my lord, the main thing.
What happens in that? Now, if lordship kindly takes, what was acquired is 172, my lord. There's a link between this writ petition with the other, though that is argued first. But the reason for invoking the urgency is related to 172.
It's not there, my lord.
Because
Greatest respect.
there is a letters written by the APMC. My lord, APMC has written letters to the state government saying 172 acres, what has been acquired is not sufficient. Therefore, kindly proceed with acquisition of 100 acres. There's a link, my lord. Until and unless both writ petitions are heard together, my lord, I'm actually ready. I have in fact requested, my lord, senior can complete it before vacation.
My lords, another 1 hour, I think Mr. Raghavan will complete anytime.
I will not take more than 20 to 30 minutes max, my lord.
Even on Tuesday.
ಅಲ್ಲ, ಅದು ನಂಗೆ ನಮ್ದು ಪಾರ್ಟ್ ಟೈಮರ್ಸ್ ನಾವು ಇಲ್ಲೆಲ್ಲ
We held at 4
ಅದಕ್ಕೆ ಎಷ್ಟು ಬೆಂಚಸ್ ಇದಾವೆ ನನಗೆ, ಪ್ಲಸ್ ಕಮಿಟಿ ಮೀಟಿಂಗ್ಸ್ ಇರ್ತದೆ. ಸಿಂಪಲ್ ಇರಲ್ಲ.
4 o'clock, my lord. Raghavan.
4 to 4:30 will do.
4:30, he will finish his argument on Tuesday.
ಮಾಡ್ಬೋದಾ?
ಆಯ್ತು ಸ್ವಾಮಿ, ನಾನು ಬರ್ತೀನಿ. ನಾವು ಹೇಳಿದಾಗ ನಾನು ಬರ್ತೀನಿ. ನಾನು ಯಾವತ್ತೂ ಕೋರ್ಟ್ಗೆ ಇಲ್ಲ ಅಂತ ಹೇಳೇ ಇಲ್ಲ. ನಾನು ಲೈಫಲ್ಲೇ ಹೇಳಲಿಲ್ಲ.
No, I apologize, my lord.
No, it's all right. It's all right. Sometimes held up ಆಗ್ತೀರಿ. ಬಟ್ ನನಗೆ ಬಿಫೋರ್ ವೆಕೇಶನ್ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮುಗಿಸ್ಬೇಕು. ಐ ಹ್ಯಾವ್ ಟು ರೈಟ್ ದಿಸ್ ಜಜ್ಮೆಂಟ್. ಐ ಕ್ಯಾನಾಟ್ ಕೀಪ್ ಆನ್. ಓನ್ಲಿ 3 ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ ನನ್ನ ಹತ್ರ ಬರೆಯುವಂಥದ್ದು. ಒಂದು ಇಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಇದೆ, ಇದೊಂದು 2-3 ಅಷ್ಟೇ. ಬೇರೆ ಇನ್ನೊಂದು ಯಾವುದು ಇಡೋದೇ ಇಲ್ಲ. ನೋಡ್ರಿ, ಯಾವ್ದಾದ್ರು ಒಂದೇ ಹಾಕಿ. ಯಾವತ್ತಿದೆ? ಟ್ಯೂಸ್ಡೇ ವಿ ಹ್ಯಾವ್ ಅನದರ್ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಮ್ಯಾಟರ್.
ಮಂಡೇ ಆಗ್ಬೋದಾ?
ಮಂಡೇ ಏನಿದೆ, ಆಗ್ಬೋದಾ?
ಮಂಡೇ
ಬರ್ತೀರಾ?
Wednesday, my lord. I am always ready. My learned senior also, he is too busy.
Wednesday ಹಾಕೊಡ್ರಿ. 4.
Very well.
ಕಡಿಮೆ ಮ್ಯಾಟರ್ಸ್. ಕಡಿಮೆ. Mr. Holla, let us see. Hopefully, Mr.
17.
Raghavan is 17. Raghavan will come. 18th.
Yes. 18th.
ಇಲ್ಲ, ನಾವು
ಆಯ್ತು, ಅವ್ರು ಮಾಡಿದ್ರೆ ನನಗೆ ಒಂದು ಸ್ವಲ್ಪ ಏನಂದ್ರೆ ಆಮೇಲೆ
There is too much intent.
ಏನಿಲ್ಲ ಇರ್ಲಿ. ಅವ್ರು ಮಾಡ್ಲಿ.
ನಿಮ್ ಕಲೀಗ್ಸ್ ಯಾರನ್ನಾರ ಇರ್ಲಿ ಅಷ್ಟೇ.
ಆಮೇಲೆ ನನಗೆ ಅದಕ್ಕೊಂದು
ಅದಾದ್ಮೇಲೆ ಶಾರ್ಟ್ ಒಂದು ಏನೋ
I'll have to cooperate. Ultimately, we must also cooperate with the judge to, my lord.
ಅಲ್ಲ, ಏನಿಲ್ಲ, ಹಂಗೆ ಇದು 15-16 ದಿವಸ ರಜೆ ಇದೆ.
ಗೊತ್ತಾಯ್ತು, ಕರೆಕ್ಟ್. ನ್ಯಾಚುರಲಿ
ಕೆಲಸ ಮುಗಿಸ್ಬಿಡ್ಬೋದು.
ನ್ಯಾಚುರಲಿ, my lord.
ಫಾರ್ ದಟ್ ರೀಸನ್
Ilde idre this, my lord, adds on to your lordship's the
That's
pressure.
pressure.
I know that. I know that.
Thank you. Chala. 84.
Also, Raghavan doesn't turn up, would be humiliating. Take out this one in that. These two.
This was in.
Yeah, that's what I said. Take out this one in.
Yeah.
Took the parent.
ಫೈಲ್ ಆಗಿದೆ ಸ್ಕೂಟಿ ಪಾಸ್ ಆಗಿದೆ
ಇಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿದ್ರೆ ಗುರುವಾರಕ್ಕೆ ಹಾಕ್ಸ್ಕೊಂತೀವಿ. ಗುರುವಾರ. ಆಯ್ತು ಸರ್.